mention for inclusion in the operational. Extreme item, family pension, my lord, Russian can see this order, 100% visual, my lord, constitution is order, my lord. Family pension, my lord, any date, any time, it could be that.
Affidavit in opposition has been filed.
Yes, ma'am.
দিয়ে এটাও হিয়ারিং এর যেদিন দেবেন না দিয়ে দিন। Yes.
My lord, may I be permitted to mention one matter from the urgent determination of Justice Bhattacharya? This is relating to a land acquisition proceeding in respect of a Debottar property where the deity was never made a party and no notice was ever sent to the deity. Now, what the state respondents are doing, they are started construction on the said property. I'm
Yes.
beseeching your lordship.
Yes.
My lord, this is regarding the writ for irregular practice adopted in tendering procedure by the BSN authority and BSNL authority. My technical bid has been rejected with extraneous.
It's a motion or hearing?
BSNL.
Motion or hearing? Motion stage or hearing?
Today itself filed.
No, group 9 I don't have determination. Yes.
My lord,
Especially fixed.
I don't have determination for group 9 matters. Yours is a group 9 matter. Yes.
My lord, may I be permitted to mention a matter for upgradation? My lord, this matter appears under the item 636 of my lord's list. My lord, the petitioner is appointed as a municipal amin on casual basis in 2004. My lord, after that, multiple applications have been made before the local authorities for making it a permanent position. My lord, the petitioner has been in that position for more than 10 years.
It is appearing in the list. It
Yes,
will
sir.
be taken up in due course. Yes.
My lord,
No upgradation.
Item number 614 already appearing in the monthly list, daily list, group 6 hearing matter. This matter was listed after I mentioned on the last option only. The main urgency behind this mentioning that day as well as today's mentioning is, if this matter is not heard within next 1.5 weeks, that is within this month, the matter may get infractuous.
Why?
Because the petitioner is going to retire right after this month only. The matter,
What is your claim here? What is the writ petition for?
the matter is relating to the CPS benefit of the employee of a Durgapur Projects Limited.
Oh, so he'll get it after retirement. What is the problem?
No,
Yes.
the petition may get affected.
All of it will be regularized. Yes. Yes, Mr. Chakravarti.
later.
Yes.
Correction order to Lordship on 10 December.
Correction, please. What is the
Order. The Lordship was fixed to delete the matter, but the appearances as well as the order on a completely different matter has been recorded.
Yes, this was supposed to be released. কে নিল? এবি নিলেন। এটা সোমবারে দেবেন, সোমবারে দিয়ে দেবেন ফর কারেকশন। Yes.
The Lordship.
Yes. To be mentioned দেবেন, to be mentioned শুধু দেবেন।
May I mention item number 589?
To be mentioned শুধু থাকবে।
May I mention item number 589 of the case list? This is appearing under the heading application. Because I was humbly praying that this application may be taken up either today at 2 p.m. or maybe on Monday.
Application was called on Wednesday. Whatever applications were there.
This is listed today, it was not there on the Wednesday list.
What is this application?
This is because of a subsequent development. Our submission would be that writ petition may be disposed of. Because now, the CESTAT has passed the order merits, and the department in a subsequent procedure has accepted the CESTAT's order in Assisi's own case. So we are saying that.
So on the next Wednesday, when I take up application, I'll be.
I'm grateful.
Lord, item 641 to 673 of your Lordship's Lord, today's list. Lord,
641.
Page Lord 366.
366.
366 page number.
Yes.
Yes, my lord, 641 to 644 are same matter. Lord, I was the ex-vice chancellor of the Vishwabharati University the day I retired. 4 frivolous complaints were lodged against me. Lord Justice Joysen Gupta stayed everything till disposal. It will take not less than 5 minutes for my lord to decide the matter because none of the
Not before vacation.
my lord gives me a date after the vacation.
I'll give it after the vacation. I'll give a date.
Lord,
Just before the vacation
and
is possible.
I understand. And 645 to 673, these are matter relating to 3G of the Highways Act. Lord, arbitration, I just want a liberty from your lordship to go back and join the arbitration. So these all 30 matters can be decided in 1 minute. So all these
645 to
645 to say 673, all these matters are similar matter. Now arbitration was done without hearing us. I will show my lord that your lordship may allow us to go and participate there.
So
Or
this also is a hearing matter.
hearing matter,
After
but not,
vacation we'll
yes,
take up.
if my lord gives us a date, not I can come
After
back.
the vacation,
Why I am
I
telling you,
can't fix it now. Before after the vacation, a date. Fixing it before the vacation won't look good.
No,
Once the court
why
reopens,
I am insisting, I tell you also, I know it won't good, but before Justice Chatterjee it was there, file went down with the change of determination. But I can't say many things in court, what we had to do to bring the file to a lordship's court. My lord allowed the mentioning on 3rd of November. It took more than 1.5 months to get the file to the court. The department is completely not functioning. So if there is a change in January, again this will go down. That's the only point of worry for me.
Before the vacation, even if I fix, there is a change, it will go wherever it
At least those dates I can show.
It's there in the list.
Very well, Lord.
Yes.
My matter is that serial number 355, your lordship, praying for update. The issue pertains to your lordship rejection of appeal petition on account of delayed filing of appeal, your lordship.
355.
Yes, your lordship.
So delayed filing of appeal, what is the urgency? It will appear in due course. Yes.
This is for upgradation. It is already running in the list at item number 638, your lordship. This is the second round of litigation. In first round, the petitioner got an order in his favor. After that,
What is the urgency?
The urgency is, your lordship, the petitioner is losing like financial losses and losing on interest, your lordship.
On what?
On tax amount paid, there is a double taxation in this matter, your lordship.
Is it? Yes.
Your Lord,
It will
new
appear in-
motion praying for inclusion.
Yes.
My Lord,
Item 690.
Hearing matters, I will not be able to upgrade. Yes.
my Lord, I am mentioning for inclusion in TV list. My Lord, it's a tax matter and the
Inclusion,
government
please give. Don't need to mention, please.
My lord has already made up his mind of not upgrading, but my lord, item number 595, it will not take more than 5 minutes because
After
civil
vacation.
court has given order. It's an
After
admitted
vacation,
use,
after
my lord.
vacation. No, not before vacation. No more
Well,
hearing
then
matters
kindly
before
give me
the
liberty
vacation.
so that I can mention after vacation for
Yes, you already
upgradation.
have that liberty. I just now said. I have already decided few matters which will be upgraded where pension is withheld.
My lord,
Somebody's academic year is going to be
my
lost.
lord,
Only
definitely those
not
matter
other
requires.
matters. Otherwise, all the matters are urgent. Every matter is urgent for every litigant. So,
Grateful.
yes, madam.
my Lord, I have a mentioning slip to submit for Power Electric. And
Mentioning slip for
Power Electric India.
what is this group, madam? Under which group is your matter filed? Group 9.
Actually, I am new here.
Yes, no matters. What is the matter? देखिए আমরা দেখে নেব দিন দেখি আমাকে দিন হ্যাঁ ট্যাক্সের ম্যাটার দিয়ে দিন আমি সেটা আর্জেন্টে দিয়ে দিই it will appear as urgent motion.
Thank you, ma'am.
Garnishee proceeding start হয়েছে the bank account attached হয়েছে. What is that?
Same tax matter.
দেখেন state tax. You have issued garnishee notice, you have attached the bank account. Settlement of dispute দিয়ে দিন urgent.
Thank you, madam.
Lordship, Your Lordship, may I be permitted to mention one matter, my lord?
Mentioning again, what
My
are
lord,
you doing all these?
my lord, I thought my lord will take to be mentioned first as per the list, so I thought I'll just wait.
is extension of interim order.
Now, my lord, I'll sincerely apologize. It was my error from my part. Your lordship, I had mentioned this matter for extension of interim order. Firstly, I sincerely apologize. What has happened, my lord? Over here in my mentioning slip, I had written the correct cost title name, and the details in the grounds were correct. However, my lord, in the top, the case number, it was a typographical error on my part, my lord. It was a complete
What happened? Wrong matter is appearing.
My lord, I had mentioned two matters, my lord, so it was my error that I had mentioned, I had given the details. My interim order is expiring on the 15th, my lord.
So what to do? If
My
that
lord,
matter
may
is
kindly
not
keep the
appearing
matter
in
on
the
Monday.
list.
I
Monday
sincerely,
दे दें? Yes.
I'm
Monday
grateful,
दे
my lord.
I'm grateful, madam.
I'm grateful, my lord. I'm
दें।
informed.
এইটা বার করে দিন, এটা তো আমাদের নয় matter.
My lord, I am for the petitioner in this matter. My lord, on last occasion, your lordship was my lord heard this matter, and yesterday the matter was
Yes.
heard.
My lord, I am for the private student. 11 and 12.
देखिए Yes, so subdivisional officer has written to the assistant engineer. It is not the assistant engineer who has written that.
Well, I have no nexus, my lord. May I get a copy of?
Yes, you give a copy. If you have a copy, please hand up a copy to him. He is acting on the basis of the subdivisional orders, officer's orders.
that
So
is-
there
what
is
is
no
that mean?
illegality.
What is this harped upon me, my lord? I am in my lord, my annexed in the writ petition.
Not required. I have seen it. There is no illegality in this.
My lord-
The order which you are impugning herein
My lord,
is a notice seeking implementation of the order which you have challenged after the expiry of the period of limitation.
No,
How
my
can
lord.
the writ court help?
your lordship kindly come to my lord your
I
lordship.
have seen yesterday only.
Yes, my lord, there is no independent finding with regard to the unauthorized construction.
There is a finding. Don't say that. He has gone way ahead of what
Well,
his scope of inquiry was, and he has said that if the remaining portion of the boundary wall is removed,
Well,
now the problem will
no,
raise Kali
my-
Puja.
my lord, may I
Notice has
take
been issued, my lord, on the basis of the order which has been passed by.
kindly come to my
Wait for your turn.
well, kindly come to my order, my lord, the page 64, my lord, the order of 2nd May 2025.
Yes, I've read it yesterday. You placed this.
Yes, my lord, your lordship kindly see the 67, my lord, the operative part.
Yes,
My lord,
I've
there,
seen.
my lord, there is my lord, so my lord, the order of the my lord, 10-3 authority. My lord, kindly see the order of the 10-3 authority. The claim portion of the boundary wall, my lord, may I just repeating, my lord, as written in the deposition of the petitioner, has been demolished. Now they can run grocery shop without obstacle. The problem of the livelihood is duly been removed.
Thereafter,
if the remaining portion of the
yes,
boundary
so
wall
this,
is removed
if
now,
if the boundary wall is unauthorized, whether remaining portion removal of the remaining portion will cause inconvenience to somebody else during something or not is not his scope of power. That is not within his domain. He has exercised power beyond his domain. I am not to comment on this in any case. If he has found that there is an unauthorized construction, he is proceeding. How can I stop?
no, my lord, kindly appreciate, my lord, the last portion.
I have
my lord,
appreciated. It doesn't say that it is the remaining portion of the boundary wall is not unauthorized or it is authorized, it is legal, it is valid. It has not said so. This a prima facie reading of this, meaningful reading of this rather, makes it clear that the entire boundary wall was unauthorized. Portion of it has already been demolished by the complainant. A portion of which falls within your area has to be demolished.
my
That is what it
content,
means.
my contention was that the report of the block land and was never served upon it. That is my face.
Those are all on merits. I cannot decide here. You ought to have said this before the writ
kindly
court.
appreciate the notice.
You should have challenged this order then.
We have been already challenged.
Challenged after expiry of the period of limitation.
The
You
statutory.
should have challenged and you should have taken stay there.
Because my understanding, the order of the SDO does not reflects with regard to demolition, immediate demolition. With
I
regard,
can't help it, sir. There is an
10-3 order is says that with regard to immediate demolition. Kindly see the order of demolition was order was passed on 2nd of May 2025. Now, the
you see item 4. It clearly shows that it's illegal. Item 4C.
the private
Please read. Yes, read.
the private respondent as well as local villagers have informed in writing that they will demolish the remaining portion of the boundary wall and club, and if any government project is taken up on that.
So this shows that it is authorized. If it is authorized, whether government project is taken up or not, it will remain. Somebody is building, if it is authorized merely because a government project is going to come up, it will be demolished unless there is an acquisition or requisition of any such sort of thing. If this kind of an observation is made, it goes on to show that there is a, sir, I cannot.
Only thing, the notice,
I will not interfere. I have said so. I am passing that order. You please.
the only thing, you'll also kindly appreciate. May I just give a copy of the notice, which is the kindly direct me to copy of the notice, the notice and me the order, it is contrary to the order, the notice is something, the order is something else. The order does not say about with regard to immediate demolition. Now, the notice is something else, which is the order of the SDO is never challenged by the petitioner also in the appeal court.
Not required. Petitioner is, he has demolished his portion, so he is not required to challenge. You are supposed to challenge it.
Kindly see the order of operative part. This says that if in future any government project will be carried out, then in that case, there is no immediate necessity for issuing the notice. Only to save from the rule.
Where is the order passed in contempt?
Kindly see the and with due respect. Kindly see,
please wait. Your running commentary is not going to help you.
Page 71, my lord.
Later, which I have given over, that's the direction. In the petition, it is page 24.
Yes, I will clarify that if any step is being taken in compliance with the order dated such and such, that will not stand in the way.
May I just with due respect, kindly come to page 72 once. Page 72, third paragraph, Mr. Oil Manager, start from, yes. Mr. Oil Manager, the learned advocate appearing for the alleged contemner, files a report dated November 18, 2025, issued under the signature of the alleged contemner 1, showing that the disputed area has been encircled with the fencing within bracket Calcutta, and the contemner has taken possession of the subject land, but no further step has been taken. But the fact remains, the portion of the boundary is already demolished. The report does not show that. Report says that they have been taken possession with the encircled.
You should have challenged the report by way of appropriate appellate authority's order. They carried it in appeal before the appellate authority. Sir, before the writ court, I am not going to enter into all this. These are all factual disputes. Where there has been a fencing, where there has not been a fencing. Is it the scope of a writ court?
No,
Can it be decided on affidavit? No, sir.
Only thing, you will kindly direct, since I have a statutory appeal filed, the statutory appeal, I have a right.
I will direct this statutory appeal to be decided expeditiously. That I can direct.
Right, kindly. May I get a copy of the report?
Copy of report?
You last time just handed out your told.
Copy of the letter. Please give a copy of the letter to him. First of.
One copy also. One copy of the report is.
You ask for it.
One last. The thing that it has been decided that it has been postponed on 30th December 2005.
Very well. In the meantime, take steps.
No.
Get the appeal decided before that.
My lord, I'm deeply obliged.
I'll direct that the appeal to be decided.
I'm deeply
obliged. This writ petition takes exception
My lord, Shonjib Chakraborty is on behalf of the petitioner. He is not well, so kindly take this matter after.
An adjournment is prayed for on behalf of the petitioner.
But I have produced one.
Today I am.
Good.
But I am also grateful. I am also grateful. But the matter has to be ended.
It was my misfortune that day. 2 days only I came online.
Only before Mr. Chakraborty starts, my lord. But I found a judgment of my lord, the High Court at Kerala. But they, my lord, said in one line they said there is a notice of 94 and 106. But the Kerala High Court decides that only the section 107 bank can be attached, and in the
But here the problem is territorial jurisdiction.
my lord,
Mr.
yes.
Ghosh,
Yes, my
kindly
lord.
think of it in this way.
Two issues are there.
Kindly think of it in this way.
Hmm.
Part of cause of action has arisen within the jurisdiction of this court. There is no doubt about it, because your bank account has been attached here. But this part of cause of action that has arisen, the attachment of the bank account, is a small part of the greater investigation that is being carried out in some other state.
Yes.
Now, in terms of Kusum Ingot's case,
My lord, I have shown Naval Kishore also.
yes, Kusum Ingot's case, it says that even if a part of cause of action arises by applying the doctrine of forum convenience, the court should wash off its hands.
Yes, and I am grateful.
So why should you not go there?
Kindly
Why
take,
should I interfere here?
kindly take my supplementary evidence once. Your lordship gave me liberty to file
Yes,
supplementary evidence. Kindly take
But
supplementary.
even then, that will not.
Not only my lord, my bank account is within the jurisdiction of your lordship, my lord. There are other facts also, and those facts are pertaining to the investigating agency who is not appearing before your lordship. Several notices. Again, I have.
Even then, if they are not appearing, also
My lord,
for them,
territorial
territorial jurisdiction is not for their non-appearance. Territorial jurisdiction is.
Yes, absolutely. It's a point of law, my lord. Point of law. And that point of law, my lord, depends upon the bundle of facts which arose to the my lord, cause of action. Your lordship knows that.
Cause of action is there. I am also not saying cause of action is not there. Have you seen Kusum Ingot's? Please read Kusum Ingot's.
Yes, ma'am.
First judgment I am important.
Yes,
You have
ma'am.
annexed Kusum
My lord,
When first judgment I have annexed, Kusum Ingot's. And the relevant paragraph to the paragraph 80 and then 27, 30.
my lord, before Kusum Ingot's, my lord, kindly take, my lord, that is a, my lord, after judgment, my lord, that is Naval Kishore, that also takes care of, my lord, Kusum Ingot and my lord, process judgment. Kindly take, my lord,
I have also
Naval
annexed
Kishore, my
another
lord.
judgment of the Honorable Supreme Court in Summit Online in 2023.
Yes, Naval Kishore.
Naval Kishore, my lord, I have handed over already, my lord.
Yes, it's there.
But kindly take, my lord, paragraph 16. Naval Kishore copy thaklo kaita dire. Paragraph 16, my lord. Paragraph 16. And my lord, paragraph 12, Kusum Ingot has been taken care of, my lord. Paragraph 12, my lord, there is a Kusum Ingot has been, my lord, dealt with, my lord, by this judgment. In paragraph 16, regard being had to, my lord, to the discussion made here and above, there can't be any doubt that the question whether or not cause of action wholly or in part or filing of a writ petition has arisen within the territorial limit of any high court has to be decided in the light of the nature and character of the proceedings under Article 226 of the Constitution. Your lordships has, my lord, pointed out this portion of the, my lord. That, my lord, it is desirable or not for your lordships, my lord, to enter into the dispute, my lord, when the, my lord, investigation is running, my lord, in the, my lord, the state of Arunachal Pradesh. That is, my lord, the only question, my lord. First, my lord, that investigation is not against me, admittedly. Admittedly is not against me. My lord, I
cannot decide here.
My lord, I know, my lord, that not against me also, my lord. My lord, again, my lord, in order to maintain a writ petition, a petitioner has to establish that a legal right claimed by him has been infringed by the respondents within the territorial limit of the court's jurisdiction.
Right, I am agreeing with this.
My lord, kindly
no
take,
problem.
my lord, kindly take paragraph 17. I am not, my lord, taking much time. My lord, paragraph 17 is last line, my lord, prima facie. Last line of the, my lord, last sentence of the paragraph 17, prima facie. Therefore, considering all facts together, a part or fraction of cause of action arose within the jurisdiction of Patna High Court, where he received a letter of refusal disentitling him from disability compensation. So, my lord, he received a letter in the, my lord, the within the jurisdiction of the Patna High Court, my lord. So, my lord, Supreme Court hold that, my lord, if you, my lord, where, my lord, the arrow hits, that's the cause of action arose. Your lordship is, my lord, also saying that the cause of action also part cause of action arose here, my lord. And, my lord, now, my lord, I am not against the investigation. If I have participated in the investigation, I have said so in my, my lord, my lord supplementary affidavit. They came here. They took my, they my lord interrogated me in the, my lord, the Maniktala police station. That is, my lord, admitted. They, my lord, investigated here, but I do not have any business over in the Arunachal Pradesh. I don't have anything. It is the case of a GST, my lord, that, my lord, the someone, my lord, I have, my lord, availed ITC of 3 lakhs rupees, but not utilized. That is my case. That has been, my lord, interrogated. That is why, my lord, bank account has been, my lord, attached. And my 2 lakhs 90 for 2 lakhs 96,000. Recently, man, another judgment, though that is considered judgment in live law, my lord, saying that the part that 2,96,000 can be, my lord, seized, not, my lord, cannot be, my lord, attached, can be, my lord, seized under 106 if the notice given is a proper notice, my lord. 106 that can be seized, and on or over, my lord, that amount I can, my lord, have it because I am a businessman. Today, my lord, equity, my lord, equity says, my lord, the equity, your lordship knows, equity says, my lord, I cannot be, my lord, for the, my lord, long period of investigation and trial, my lord, my bank account has to be, my lord, attached, which is within the jurisdiction of your lordship. And every communication I have received here and, my lord, from here, my lord, I have, my lord, given my communications to them, my lord. I never went there. They, my lord, came here to interrogate me because I do not have. The only thing, my lord, they have a thousand suppliers of that company against whom that, my lord, the investigation is going on. And, my lord, the only thing is there, my lord, I have, my lord, availed 2,96,000 rupees, but I have not, my lord, utilized it. That is, my lord, section 16 of the, my lord, GST Act, your lordship knows, my lord. And that is, my lord, in the writ petition also. My lord, Mr. Chakraborty's clients gave me notice on the same, on 2,96,000 rupees. That is, my lord, in the, my lord, annex in the writ petition. And, my lord, your lordship, my lord, vagueness of the, my lord, I don't have that notice. That is why I could not take that ground of vagueness. My lord, kindly see the notice, the vagueness in the notice, my lord, which, my lord, my lord, bank here, my lord, received from them. The vagueness in the notice, my lord, kindly take the notice, my lord. That handed over by the, my lord, the bank before to your lordship.
Yes, it's there.
There is absolutely vague notice, my lord. Nothing transferred there. But there is the arbitrariness, vagueness, and, my lord, the major portion of the, my lord, cause of action arrows, my lord, within your limit of your lordship, my lord. I can't be, my lord.
Yes, Mr. Chakraborty.
But I have two-fold of submission. But I may be wrong. But I have two-fold of submission. Number one, if your lordship takes up the judgments relied upon by me, the first one is Kushumingar. Your lordship is well aware of that. I'm not going to. Kindly take the second, the 2023 Supreme Court, that is Summit Online against State of Goa. Well, it starts from page number 7. Well,
Yes.
what I am on, where kindly take para 14, stateway. While dealing with an objection as to the lack of territorial jurisdiction to entertain a writ petition on the ground that the cause of action has not arisen within its jurisdiction, a High Court essentially has to arrive at a conclusion on the basis of the averments made in the petitioner memo, treating the contents as true and correct. Correct. Then, my lord, paragraph 15. Towards middle, my lord, at the right hand side, it starts with however. However, in the context of a writ petition, what would constitute such cause of action is the material fact which are imperative for the writ petitioner to plead and prove to obtain relief as claimed. Last sentence, those facts which are not relevant or germane for grant of prayer would not give rise to a cause of action conferring jurisdiction of the court. So, my lord, after considering Kusum Ingot, the Honorable Supreme Court has reiterated that the germane of cause of action, yes, it is settled position of law, my lord. Even if a small cause of action arises, part cause of action, Honorable Court has the territorial jurisdiction. But the question is, what Kusum Ingot laid down, the forum convenience. That according to the Honorable Court, in each case, my lord, I'll show some other judgments also have been. Throughout India, all the Honorable High Courts are saying, Kusum Ingot has left it to the respective Honorable Court to decide in each case on its facts and circumstance that what is the forum convenience. The forum convenience is not only for the petitioner, the forum convenience is also for the respondent. A writ of certiorari is required to issue to quash or set aside any order, whether it is completely illegal or not. The documents are lying in the office of a respondent who is to be issued with a writ of certiorari to look into this or to quash that order by the Honorable Court. It is the, well, I am borrowing my wisdom. So in that case, the forum conveniency for the respondent is also to be looked into. Now, what is the case in this case? Well, we'll kindly see the writ petition. Well, in the writ petition, your lordship, well, subject to correction by my learned friend, I have found the entire prayer is, kindly see the prayer, kindly issue writ of mandamus directing respondent to disfreeze the bank account. So this is directed against ICICI Bank.
Not a problem.
I'm not on that.
So don't argue that unnecessarily.
I'm not arguing that.
Don't argue that.
Then,
it's not a problem because
then,
he's principally against a government authority. So
I'm not against Melon. Against whom?
Of course, against the police.
Police.
Yes.
Then to this Honorable Court has the jurisdiction.
Yes, of course. If it affects him here within the jurisdiction of the court, don't argue that. Forum convenience is not that the court does not have jurisdiction.
I'm not saying.
So don't argue that.
But group 4.
You draw your line.
But I'm saying
I can always direct them if the
expectation is 4.
Whatever group it is.
Yes. Now they are challenging basically in the writ petition. They have prayed for defreezing of the account against ICICI Bank. The entire writ petition does not contain any pleading with respect to the cause of action. Now they are saying there is only one single ground subject to the entire petition is against CGST. No prayer against CGST, subject to correction by my learned friend opposite. Only one thing. Kindly take page 16. Ground number 12.
Yes.
For that petitioner states that the writ petition challenges the action of respondent number 1 in debiting the amounts of tax from electronic credit ledger. Has it been pleaded? No. This is the pleading. This is not the case. The entire writ petition nowhere says that the notice issued by the Itanagar police is required to be set aside. There is no such prayer. Now they have invoked the jurisdiction of the revenue group 4 before this Honorable Court by making CGST a party, by saying action of CGST is illegal, by praying for defreezing the bank account. Now their case before your lordship is that the order issued by Itanagar PS is illegal and requires to be set aside. I humbly submit before your lordship. I've relied upon a couple of judgments. If your lordship wants, I can rely on the paragraphs number. I can indicate just. I won't spoil the valuable time of this Honorable Court. Question
what
is
about the supplementary affidavit? That
yes, supplementary affidavit. When I took the point of territorial jurisdiction, your lordship directed them to file a supplementary affidavit. Now, in this supplementary affidavit, what they have submitted kindly. It's a 2 pages supplementary affidavit, my lord. In the supplementary affidavit, first page, the first paragraph, they said that they have no business in Arunachal Pradesh, and Arunachal police interrogated them in Maniktala PS on 13 January 2025.
Yes.
Correct, my lord? This second paragraph, they says that CGST authority submitted prosecution complaint under section 134 against such and such person. Third paragraph, they have said cause of action consists of bundle of facts.
Well, no prayer for quashing of the order of the Itanagar police. And the prayer is being framed before your lordship for the respondent who has no office or anything over here. Their case is that the ICICI Bank debit freeze has frozen. Now I leave it to your lordship to decide on the matter, my lord. This is my only contention. That there is nothing against CGST, whether this can be a group 4 matter at all. No prayer against the Itanagar police order.
Yes, there is no prayer for quashment of that.
Nothing.
Malad, set aside Malad of the Malad that set aside of the communication. That communication Malad says Malad the Itanagar police Malad. Or pair B Malad.
No, but this letter ought to have been challenged.
Malad letter was not Malad not known to me.
No, you could have asked the bank for that. You could have written the bank for that and challenged that.
Malad, when we returned to the bank, Malad, bank said Malad on the Malad Malad communication Malad from the Itanagar police Malad they.
Very well. From the bank, you could have asked for a copy of the communication. That
That
is
has
not
not
a
been
confidential document. Bank could have definitely provided you the copy. You should have challenged that. That
Malad,
is not under challenge.
The section 94
Malad,
count is also not there. In the
Malad judgment Malad.
That ground can be taken even if it is not.
Malad judgment Malad delivered by my Malad friend Malad only.
But what about the prayer? You don't
Malad
have a prayer.
Malad the prayer
and he's right that this does not appear to be a group 4 matter that way.
Malad, this is not a group 4 matter. It's an assigned matter. Malad is a residuary matter assigned before lordship. But that's not a group 4 matter, Malad.
Then that point goes.
Malad. And Malad, your lordship knows Malad, writ of Shashirarai. This is not a Malad quasi judicial or judicial
but in
order.
any case,
Malad, let me come back to the Malad summit judgment. Malad, my learned friend Malad cited Malad. Malad, only 2 minutes. Kindly take paragraph 2. What is the challenge? Paragraph 2. What is the challenge when in a summit judgment? Malad?
Paragraph 2 of?
Paragraph 2 of the summit judgment. Malad, summit online judgment. Malad, my learned friend place. Malad.
But the second judgment I have.
Malad, summit online. Summit line online. Malad, that is at Malad, page 7 it starts from the compilation. Kindly take page 8. Paragraph 2.
Paragraph 2.
Malad, from the second sentence, third sentence, the appellant.
Please submission, your lordship will consider.
Malad, I am coming to that, Malad. Kindly take Malad this, Malad.
Malad, the judgment says the Bombay High Court, the larger bench of Honorable Delhi High Court says that the authority passing the order, which order is under the challenge, maybe there is plenty of honorable courts who are having part cause of action. Malad, lots of different. Malad, I showed your lordship summit. Thereafter, your lordship will find Madras High Court, Venkata Shairam Trader. Your lordship will kindly take. No. It is not in summit. Summit says it has to go by pleading in the petition. Nothing beyond that. Malad, the next judgment, Madras High Court, is on the issue what I said on the certiorari. Malad, para 21 at page 14,
Civil procedure code section 17.
page 14, para 21 and para 23. The writ of certiorari in para 21 and para 23, since the settlement commission is located at Madras, the matter should go before that honorable court. Now, the next one is Bombay High Court, Sachi Agro. Kindly take page para 9 and para 12, 12, 13. Since the authority concerned passed the order, jurisdiction is at the cause of action is in Bombay, para 9, para 12 and 13. Well, can I take para 12? Page 17, 17. That is done. That is the Madras High Court. Okay. Well, coming. Well, para 21. Bearing. Yes. Passed on. Here. Yes. All the same. Not expert. Correct. Correct. That is all the judgment. Those are the judgments. Not anything when notice has been issued. Now the question comes the investigation. Maybe an absolute illegal order has been passed by an investigating authority. Can you visualize one situation? As my learned friend was saying, thousands of suppliers throughout India. Your Lordship has seen in all these matters of the. But suppose in Kolkata, an officer is undertaking an investigation. He is calling upon the parties from throughout India, from several parts of India, and they are not responding. They have not responded, and accordingly, he has issued certain notice which affect his bank account at Baroda. Someone in Nagpur, someone in Kerala. So your Lordship will decide that what will be the forum convenience that each petitioner will go against the same investigating authority at their respective territorial jurisdiction. The forum conveniency, in the view of the Supreme Court's judgments and as followed by all the honorable court, has to be taken care of, my lord, because in the case of Nawal Kishore, what my learned friend was showing, if your Lordship see that paragraph only, what my learned friend was showing, it was recorded above just before the last sentence that it was pleaded by the petitioner that he is not in a health condition even to travel to any other state. That was also considered. Kindly take. My learned friend was showing that paragraph. 17. 17. Kindly take 17. 17, last sentence he has showed, prima facie.
Four times I have given notice.
Also representing an Itanagar authority.
He is also from Itanagar CJST.
Police is not coming.
They are coming to interrogate my client, but they could not coming and appear before Lordship.
Officer in charge.
Officer in charge.
My lord even can issue summons. Because they have tried at least 4 or 5 times.
And
that is what I am saying.
let me give you 2 minutes, kind.
Through register.
मतलब रजिस्टर्ड को सिर्फ 3 बजे पर पार्टी
Register of the school.
मतलब then मतलब superintendent of police can be मतलब made a party मतलब today मतलब superintendent of police can be मतलब
Pursuant to your last order dated, we served the other side affidavit of service. This matter, I don't have any knowledge, my lord. I am praying for short person. My lord, relating to GST, my lord. Oh, with the effect dated 1st July 2020, 2017. As per the Good and Service Tax 2017, and all taxes have subsumed to GST in the effect from the 1st July 2017, had memo dated 13th July 2017. My lord, prayer from point D. Responded, may I read? Page 22, my lord. Yes, my lord.
Yes. Now, my Lord, you kindly see, this is in respect of a GST claim allegedly a contract executed with respondent number 4, West Bengal State Rural Development Agency, along with the red petition, and in terms of such agreement, work order has been implemented that was executed in 2018. Now, my lord, be that as it may, it appears from record that in the year 2023, the red petitioner has raised certain dispute regarding payment to GST. My lord, kindly seize your lordship's order. Prime officer, your lordship has been pleased to direct the red petitioner to produce a copy of the contract. My lord, that has not been produced. That your lordship has insisted upon the red petitioner that you please, yes, yes. My lord, my lord, my lord. Yes, 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 my lord, that. My lord, yes, my lord, that is, my lord, that is required. Even if the claim is belated, right now I'm not arguing, but whatever.
My lord, I am praying for 1 week. Kindly fix this matter next week. No, my lord, I am praying for last chance also. Kindly fixed next week. I will try, my lord. I will try my. I will try my best, my lord. Yes, my lord. Yes, my. Yes, my lord.
But I am for the petitioner. Madam.
Last occasion, your lordship directed me to file report.
রিপোর্টটা দিয়ে দিই।
The claim arising out of a contract, but my lord, since my lord, a substantial amount had been paid prior to the filing of the writ petition. Now, my lord, the writ petition says that, my lord, that still there are dues. Now, my lord, the report was called for. The report is that, my lord, if you lordship kindly have a look at the report, my lord, after payment of a substantial amount, my lord, that is, my lord, at paragraph number 8. Paragraph number 8 at page 3 in the report. That total, my lord, the undisputed, my lord, the due 81,35,000. Now, out of that, sorry, 81,35,000 paid, sorry. Now, my lord, 40 lakhs 91,000 odd is, my lord, due and payable as per, my lord, the hour, my lord, the estimate. My lord, the matter was vetted to the engineer.
My lord, kindly see paragraph 4 first. My lord, I submitted the bill on 23rd February, my lord, 2021. My lord, then, my lord, kindly come to paragraph 7.
Paragraph 7 of the report.
Yes. My lord, in way back in 2021, that is not QWP, that is should be RWP, Rural Works Program Engineer. She conducted the inquiry verification in 2021 long back and deduct my 50% of the bill without any intimation to me. And there is no whisper why those 50% has been deducted in the report. Now they are saying, my lord, out of 1 crore 22 lakhs, my lord, they paid 81 lakhs and odd. Now 40 lakhs 91,000 due from 2021. Now we are in 2025 end. And there is no whisper when should be disbursed by them. It is totally absent. My lord, kindly allow me to file an exception to this report and kindly direct them to make the admitted amount, my lord, as early as possible. My lord, they should, my lord, if my lord, they my lord disclose the fact.
My lord, both way it cannot be. First of all, my lord,
They should disclose, my lord, in the.
My lord,
They should disclose, my lord, on what basis, my lord, they deduct my 50% of the bill. No, my lord, I should know, my lord, what is the reason for deduction of 50% of it. Yes.
I'm only direct the district magistrate, my lord, to disburse the fund so that amount can be paid. It has been mentioned in the report.
My lord, for this amount, the interest should be paid by them. This is the admitted amount from 2021.
But should kindly consider, my lord, that my lord, if he, my lord, agrees to, my lord, to settle the matter, then the full final settlement. May I tell one? May I, I have understood. But I have understood. So I am not on that. May may I tell? Let him accept this sum and let him make a representation before the district magistrate with regard to that manner he is claiming.
Then again, my lord, I have to come here.
Now, so far the interest portion is concerned, let him make it because till date there is no such representation at least. So kindly consider. But in that event, Mother, may I tell one thing? Though I am not, Mother, my stand is not that, but you kindly consider. Mother, if he files a suit, you kindly consider. Had he filed a suit,
Suja contest.
what I am telling you, even for that 40 days, even for that 40 days, if he filed a suit, then my lord, the suit should have, my lord, landed to, my lord, that be barred by law limitation. Cause of action arose much more than 3 years back. Madam, may I tell? In the between 3 years, my lord knows better than me. There is no, my lord, the letter of my lord, the admission that he is entitled to. Now, my lord, the authority agrees to make payment because, my lord, yes, there is some due. Now, my lord, it is through a, my lord, the read code. What you kindly consider? Had it been filed a suit, had it been a suit, my lord, kindly consider. I am sure, lordship, so far my knowledge goes, that it may have landed to, my lord, the dismissal of the suit for, my lord, the part by law of limitation. Madam, may I tell lordship, my lord, lordship, so kind, my lord, kindly direct the district magistrate to consider this prayer regarding. I think, my lord, it will be considered. I think so, because so far rate of interest. And my lord, is there any prayer to that extent? Madam, may I go through the prayer?
Commercial.
The reason, lordship, it has been, my lord, the stated here that, mother, paragraph number 7. Yes. The same junior, no, paragraph 6. 6 and also 6. Before and submit, after the submission of above bill, it required verification as well as scrutiny of those bills. As per order of the concerned authority, those bills were sent for verification and scrutiny of measurement as well as of amount quoted therein to the. Yes.
Well, within a certain period of time,
Rate of interest.
Get
He may not deposited the same to the fixed deposit.
mutual fund will
Or he may have, my lord, invested it and, my lord, that investment, my lord, may not yield such, my lord, return. So all these things are, my lord, the, my lord, 5%. 5%. Because this is 5.5%. 5%. Though it is not, my lord, kindly do not record it, but not. Then, my lord, the
kindly mention the rate of interest. Otherwise, my lord, it may be 1% as per their decision. My lord, kindly see the bill. Let's say 2 crore and odd. Now they said it's 1 crore and odd.
He can raise as per mother did. We cannot say anything. Bill according to them.
My lord, I'm for the petitioner. I'm praying. Yes, sir. Total immediate. Yes, my lord. All right. Today, my lord, after completion of my lord's list, 2 p.m. I'm free.
For Bombay Stock Exchange, my lord.
I'm for the petitioner. My lord, I am praying for short Passover, my lord.
My lord, every day, my lord,
No,
same happening, my lord. My lord,
my lord, the point is on maintainability.
yes, my lord. We are taking the point of maintainability.
My lord, I'm appearing for SEBI. The petitioner has challenged the freezing of shares. So the freezing of shares has been done in pursuance of 2 circulars. 2 circulars were issued by SEBI, 30th November, my lord, 2015 and 26th October 2016. In pursuance of these circulars, SEBI had directed the promoter directors, the shares of promoter directors of companies who were non-compliant with certain regulations and acts of SEBI to be frozen. And in pursuance of these circulars, the Bombay Stock Exchange has frozen the share petition. Now, my lord, this action and this direction is an appealable action under under Securities Contract Regulation Act, 45 days. This is an action.
No, my lord, I am appealing for Bombay Stock Exchange. My lord, before going into the merits, my lord, at the very outset, I would like to take the point of maintainability. My lord, this is my lord, territorial jurisdiction. On the point of territorial jurisdiction, my lord, what has happened, my lord? If let us first understand what is the action and the challenge before your lord. If this is the freezing of shares, my lord, now the freezing has been done by Bombay Stock Exchange Limited, my client in Bombay. And if they are challenging the circulars of SEBI, the circulars have also been published in Bombay. And my lord, the respondents' addresses are all in Bombay. And also, my lord, also only, my lord, what they are saying is that the petitioner is staying within the limits of the jurisdiction of this honorable court. And secondly, my lord, the company whose shares have been frozen, my lord. And also, my lord, they have not disclosed. My lord, the company is situated. My lord, the company is situated, my lord.
Company is in the memo of party, it's in there.
Yes, my lord, it is having its registered office at 4 Chandni Chowk Street. But my lord, that company is in liquidation since 2019, my lord, May 2019. And the liquidator has not been made a party. So now, since the company is in liquidation, only the liquidator can represent the company. So, my lord, the only way they are trying to assume jurisdiction, my lord, of this honorable court is that the petitioner is staying within the limits of this honorable court, my lord. So, my lord, now what has happened, my lord, no, my lord, kindly appreciate now, if they are challenging the SEBI circulars in Bombay, that cannot be done before this honorable court. And secondly, yes, so my lord, appellate remedies, my lord, what they are saying, my lord,
Let's check.
23L of
23.
Securities Contract Regulation.
My lord,
23L of the Securities Contract Regulation Act. So, my lord, it says any order or decision of the stock exchange. Now, my lord, in this case, there is no order. The Bombay Stock Exchange has frozen 615 shares of promoter, my lord, who is the writ petitioner is the promoter of this company, my lord. So the Bombay Stock Exchange has frozen certain shares, my lord, she being the promoter of the company, in light of two SEBI circulars. And on so decision, my lord, if this is that is a decision, my lord. So this happened, this act of freezing, it happened on 21st December 2016. Yes, 45 days was the period, my lord. And admittedly, my lord, even though they have not mentioned when they got to know about the freezing, but they complained about the freezing, my lord, in the year 2019, whereas the act of freezing happened in December 2016, my lord.
Lord, the petitioner can very well approach the SAT, Securities Appellate Tribunal, and
But
if,
now,
if
my
the
lord,
delay,
45 days is over, my lord.
if the delay is not condoned, my lord, then they can invoke the writ jurisdiction. Before it
But I have, but I,
Sir, petition taken.
but I have governed by this or court order by the yes, my lord.
517, my lord. I am for the respondent, my lord. 517.
Wanted a copy to it.
Order date तो बोलेगा 22nd March.
अच्छा कॉपी अच्छा वो फाइनल ऑर्डर neither I am a promoter. Neither I am a promoter. I am not a promoter. No, but I am not a promoter. No, I am just, I purchased the share from that company. No, I am not the promoter.
If that be the case,
That is a specific contention, my lord.
if that be the case, my lord, we are ready and willing to decrease it, provided the company reclassify her as a non-promoter.
Well, no hearing has been given, my lord. No opportunity of hearing.
It has been done in light of SEBI circulars.
But no order and notice has been served to me. No order. No notice has been served.
My lord, this is the SEBI circular.
I have made representation thrice, my lord. Till date, no notice has been served, no order has been served upon me.
My lord, kindly see. My lord, it says it is subject, non-compliance with certain provisions of SEBI LODR regulation 2015 and standard operating procedure.
It proved that it has been served upon me.
In terms of
Vishnu. I am engaging.
My lord, paragraph 3, my lord.
Sorry, my lord.
Every Friday you have 4-5 panels and you take the order. And after half an hour after passing the order, you come again and you start taking the.
My lord, paragraph 3, my lord, of this November 30, 2015 circular, my lord. It says, accordingly, recognized stock exchanges shall use imposition of fines as action of first resort in case of such non-compliances and invoke suspension of trading in case of subsequent and consecutive default. According to, in order to maintain the consistency and uniformity to approach the recognized stock exchanges shall follow the procedure. My lord, it is shall. Uniform fine structure for non-compliance with listing regulations, standard operating procedure. And then, my lord, October 26, 2016, my lord, 2.1, it says where a non-compliant listed entity fails to pay the fine levied as per the notice issued by the concerned recognized stock exchange in terms of para 4 of annexure 1, the concerned recognized stock exchange shall, not may, shall upon expiry of the period indicated in the notice issued by it. Yes, yes, my lord, I will consider this and come back. I do not have a copy of this. I will obtain a copy and then oblige you. Oblige you. My lord,
Sorry, my lord, I have. I realize it, my lord. No, my lord. I realize it, my lord. I may be excused, my lord.
I am for the respondent, my lord. In this matter, I am for the respondent.
My lord, that matter in which
My lord, I am appearing for union of interest.
My lord, this is a case like a restaurant. One man entered into for taking food. Without any food, they are charging. My lord, in 2017, we are brought under the SI. Immediately we paid 14 lakhs. Not a single paisa has been spent for the treatment of it. My lord, we have made a detailed representation.
Detailed representation is page 33, my lord. But my lord, there is a very limited scope of, or there is almost no scope for the interim order. If your lordship allow me to file a objection to it.
Page 48, my lord. We requested the authority, page 48 onwards.
Mr. Banerjee, you are not visible.
My lord. ওখান থেকে login করো, ওখান থেকে login করো। Yes,
Yes.
lordship. Yes.
Yes. Now you are visible. Why don't you consider and dispose of the representation made by the petitioner in
If
a
your lordship kindly see, I will certainly. Lordship kindly see, this is not the case. Case is 45A. Kindly come to page 42. I have passed an order. Now, while I am implementing order, instead of going to the appeal is 45AA is the appeal. Instead of going to the appeal, he is coming back to your lordship and say that my service is not up to the mark for which the contribution he is paying. Then tomorrow he will say, I will not pay the income tax
No
because the
service,
roads
not
are
at all
not
up to
good.
the mark. There is no service at all.
Yes,
There
yes,
is no
quite correct.
service at all.
Quite correct. He is
You have
saying that there
taken
is no service.
lakhs
So
of
he will
rupees.
not pay. He will
There
decide
is
how
no,
much
my
he
lord,
will
there
pay.
is no medical facility, nothing.
Sir, if it is not there, we are implementing. He have to say it
No,
is
no,
a
we should
government
show you
organization.
update
It is
that
a
you-
statutory duty. Then someone will
Very
not
well.
pay
What
the
is
income
his
tax.
prayer in
Someone
the-
will not.
Mr. Banerjee, what is his prayer in the representation? How is it? How is your order coming in the way of consideration of
No,
that
lordship,
prayer?
moment I have passed an order, then kindly see when he is coming before your lordship. Then kindly come to next page, lordship. Then
Yes.
kindly come to page 46.
What
Moment I
is
will.
your order? Mr. Banerjee, please place what is your order first.
Yes, lordship. Lordship, my order is page 42, lordship.
Yes.
This is an
What
order
does
of
it say? What is the
adjudication
operation?
that how much contribution is not paid by him. We calculate that.
Very
So,
well. That
lordship,
is all good. That is all good. And now what is his representation of for?
now kindly see his representation.
My lord, 48, page 48, last.
48.
Yes.
What have you sought for in the representation?
I have
So to
sought for,
keep
my lord,
themselves
they
out
have
of
sought-
coverage.
So that the
Now kindly-
order, Mr. Banerjee,
Yes,
please
lordship.
hear to the court also.
I'm
Please
sorry.
hear to
I'm
the
sorry.
court also. Have some patience. If the representation is that they should be kept out of the purview of ESI, and your order is saying that they are liable to pay this much, how are these two clashing with each other? That is for a different period. This keeping out keeping this institution out of
Bow down.
ESI will be for a
Bow down.
different period.
Bow
Where is
down.
the problem?
Bow down. Now, lordship, kindly come to the document at page 35.
No, I'll come to the
36.
document, but what is the problem in considering this unnecessarily? Why will I hear something which will ultimately come to this
Lordship,
only?
I definitely. But lordship, kindly see page 36 once. He made similar prayer. I consider. He made similar prayer. I consider. I call for documents.
Yes.
In this regard, you are requested to provide the list of such uncovered edition. Lordship has got it.
Page 36.
Yes, 36, lordship. It is a 14/3/23.
Yes.
So, lordship, kindly see the subject keeping the
Uncovered
society out of the
educational
coverage.
institute run by NGOs. Yes.
Lordship, now kindly see, I asked for the document. It's not like that. It's an inaction on my part.
Yes. Thereafter.
So, lordship, thereafter he has not provided. Now kindly come to the next page 37. Then,
Page
lordship,
37.
I am digging out what are the institution and how many employees he has. Now kindly come to the already functional in Mushidabad. I have given him the detail because he complained to me that I do not have sufficient support. So, lordship, I have given him a detail that what are the things there. Now, lordship, kindly turn to page 38.
Page 38.
Then, lordship, again I requested for the document.
No, but
He
these
has
are
not given me.
complaints. But Mr. Banerjee, once again, subject to what you say, these are all complaints against NGOs which are running educational institutions not brought under coverage of ESIC. His request by the letter which is appearing at page 48 is to take him out of the purview of ESI. Those are operating in different
Lordship,
fields.
I will. Lordship, if your lordship see that page 39 was the similar request he made.
Page 39. So that is what he seeks consideration of. Page 39 you have considered.
The lordship.
Where is the order on page 39?
No.
If your lordship kindly say if 39 is to be considered, Lordship, then we will. What he is saying is now he wants to consider what? Lordship, kindly come to page 48.
Mr. Banerjee, you have read the brief or you are reading it now with me?
Yes, my lord.
Yes, I was also on that side, so I can understand that.
My lord, although I am Union of India, I may be allowed to make some submissions.
Yes, yes, I'll definitely come to you, sir. I'll
My
come
lord,
to you, sir. I will
my-
come
my-
to you. I will come to you. Let him conclude
Yes,
once.
my lord.
Now, Lordship, if we see the letter at page 48, which he is trying to consider now. Now,
48 and 39 are same.
No, there is a
Or
difference,
not.
Lordship.
Grievances are
48 is addressed to the recovery officer.
Very well.
And 39, Lordship, now kindly come
It may
to.
be addressed to somebody else, but it is for taking them out of the
Once
purview.
once it is addressed to the recovery officer, that means he is trying to stall my recovery. Let Lordship, what was running in the mind of the Lordship, that whatever order passed, you go ahead in execution and you also consider his pay. So in that case,
that if the order is not challenged, I'm not going to interfere with the order.
right.
The order will
Now,
take its
Lordship,
course.
kindly see.
You will
Now,
consider
Lordship,
the representation
39.
without.
Yes.
You will consider this representation
39.
without touching upon that order. I'll
Yes,
clarify
Lordship.
that.
Yes. And
Yes,
Lordship,
sir.
My lord, kindly come to page 27. Their claim is contradiction. They are saying that their rate will reduce from 6.5 to 4%. Annexure P2. My lord,
No, that was
page
prayer.
27.
Subject
Their
to
prayer is on the subject itself.
They don't want the consideration of this representation now. They
Maybe.
want consideration of the representation whereby they have requested you to keep them out of purview of ESI. If you
Their
want to keep
beginning
them,
was from the deduction of
if you want to keep them, you will keep them. If you don't want to keep them, say no, you are not entitled to go out of it.
And my lord, at page 38,
yes,
annexure P4, my lord, in second para, the letter is
yes,
dated
these
6
have
March
been
23.
traced.
So, my lord, here they are seeking exemption. All right, my lord, they can. But, my lord, the list here wanted, they have not provided. Although the list has been annexed to the petition
You
now.
will consider this representation. They are not interconnected.
So, my lord, they are filing this list before the honorable court now. Earlier, they
I am
did
not
not
taking any decision on the list.
Yes.
So you are not understanding what I am submitting before you now, instead of hearing your submission.
My lord.
He has made a representation, making a request to you to keep him out of the purview of ESI.
Right.
The earlier orders which you are referring are orders whereby certain amounts have been imposed upon them for payment to the ESI. Those will not be interfered with by dint of the consideration of this representation. I have made that clear.
And my lord, their claim is that similar organizations have been exempted.
That is also not a part of this consideration.
My lord.
We have what we are trying to
to
implement.
the prayer he has made.
What is the prayer?
And Lordship, kindly come to page 22.
Page 22.
He wanted to stay in recovery, in the gist.
Now look into the
I
grievance.
don't say that recovery will be stayed. That order I am not going to pass.
Prayer is, my lord,
Prayer is to look into
grievances
the grievances of the petitioner and put the
thereby
petitioners out of the purview of the coverage.
He can always claim we will consider. Page 39, yes, Lordship.
Unnecessarily 15 minutes gone.
I'm sorry, my lord, I'm sorry.
The petitioner seeks issuance of a writ of mandamus commanding the respondents to, inverted comma, look into the grievances of the petitioner and thereby put the petitioner out of the coverage of ESIC, and further commanding them not to disturb and or harass the petitioner Bosantapur Education Society by making unlawful demand of money or in any manner whatsoever, inverted comma, closed. Full stop. Paragraph. Mr. Mustafa, learned advocate, appearing for the petitioner, submits that the petitioner has not been getting any ESI facility. And as such, the petitioner has made representations before the respondent ESI authorities, requesting the said authorities to keep the petitioner out of ESI coverage. Full stop. Paragraph. Mr. Banerjee, learned advocate appearing for the respondent ESI authorities. Respondent ESI authorities submit that this petition is a ploy to stall recovery of amounts for which the petitioner has been found liable by an order dated July 12, 2024, passed in proceedings under Section 45, capital A of the ESI Act, 1948. Full stop. That is your submission, Mr. Banerjee. It is further submitted that.
And the recovery has started. We have started writing letter to the bank also.
The petitioner, that recovery in terms of the said order, recovery of the amounts mentioned, recovery of the amounts as ordered by the ESI, by the assistant director, by the order dated July 12, 2024, has already commenced. Full stop. Paragraph. It is further submitted that earlier the petitioner had complained against certain NGOs who, according to the petitioner, were functioning without ESIC coverage.
Yes.
Full stop. It is submitted that on such representations, due action has been taken by the ESI authorities. Full stop. Paragraph. Learned advocate appearing for Mr. Gauri Saria, learned advocate appearing for the respondent number 1, submits that the petitioner had earlier made a representation dated October 3, 2018, praying for reduction of the ESI contribution, and as such, the petitioner cannot be said to be having a case for being taken out of ESI coverage. That is your submission. Full stop. Heard the learned advocates appearing for the respective parties and considered the material on record. Full stop. Paragraph. Since the petitioner contends that no facility that an entity covered by ESI, covered under the ESI Act, is being made to the petitioner, and that for such reason the petitioner has made a representation before the ESI authorities, requesting them to keep them out of ESI coverage, this court is of the view that instead of this court taking a decision as regards the aspect as to whether the petitioner should be deemed to be covered, should be continue to be covered under the ESI Act, or should be brought out of its ambit, should at the first instance be taken by the ESI authorities themselves and not this court under Article 226 of the Constitution of India. Full stop. Since the petitioner has already made a representation dated February 26, 2024.
I would request your lordship to give that 30th July 2024, because other one is to the recovery officer, which we will not be able to consider. Page 39.
Page 39.
Same prayer, same prayer.
Page 39.
Prayer for making out of coverage.
To the representation dated dated July 30, 2024, within brackets annexure P6 at page 39 of the writ petition, comma, bracket closed, to the Assistant Director, comma, Employees State Insurance Corporation, comma, thereby requesting the said authority to move the petitioner out of the ESIC coverage, comma, he has been added as a he is made a respondent.
Yes.
The said authority, i.e., the respondent number 3, respondent number 3 herein being the Assistant Director, comma, Employees State Insurance Corporation, should consider and dispose of the petitioner's representation dated July 30, 2024, strictly in accordance with law, upon affording an opportunity of hearing to the petitioner within a period of
4 weeks.
4 weeks from the date of communication of this order, full stop, paragraph. It is clarified that this order of consideration, directing consideration of the petitioner's representation shall in no way impede any recovery proceeding that might have been undertaken by the employees, by the respondent ESI authorities in execution of the order dated
12th July.
July 12,
2024.
20, page
42.
Page 42, or of any other order that may have been passed or may be passed during the time the petitioner remains to be covered by the said act.
Still under, because we have not.
So if any order is now also passed, that will also not be governed by this.
No, but
this order shall also not be treated as a mandate to put the petitioner out of the coverage of ESIC unless the law so requires, full stop, paragraph. The respondent number 2 shall be free to 2 or 3. Respondent number 3 shall be free to take a reasoned decision strictly in accordance with law, full stop, paragraph. It is clarified that this court has not gone into the merits of the petitioner's claim, full stop. Needless to mention that the respondent number 3 shall dispose of the petitioner's representation by passing a reasoned order and communicate the same to the petitioner as a reasoned order within the time above time frame. 4 weeks within the above time frame, and communicate such order to the petitioner within a week from the date of passing thereof.
But one thing, my lord, normally it should be within the radius of 8 kilometers.
That they will consider.
That they will consider. And my lord, now,
but till such time you are covered, this order will not interfere with that. That I should clarify. Otherwise, it will create difficulties. Affidavit of service.
But that amount is also heavy.
Subsequently, you will take steps in accordance with law.
I'm grateful.
I'm deeply obliged, man.
We have got, my lord, facilities. We opted to be the under coverage, but nothing. Initially, we paid 14 lakhs.
Yes, next.
Not, but we have got facilities of not 14 paisa. I am grateful. Not a single patient has been.
Yes.
My lord, I am appearing on behalf of petitioner. I am led by Mr. Taposh Kumar. Today is fixed for opposite party will place report.
This is what happens.
My lord, my lord.
I say, my lord, not satisfied of this. My client, my lord, and my lord, only my lord, I made a communication to the my lord. I have read this judgment also, my lord, and my lord, I wrote a letter to the commissioner of police to assist police authority restoring this physical possession of this property. And my lord, also my lord, police also reply, my lord, district magistrate, please pass a written order with appointment a magistrate. We will assist this police and my lord further restoring possession. My lord, finally in these circumstances, my lord, I am my lord 2 weeks more time, my lord.
Very well. In 2 weeks, they'll try and give you possession.
My lord. Then my lord, 1 week after.
Yes, yes.
Reopen. 10th of
Very well.
And
Uh,
next matter, my lord, 519, this is the same communication, my lord. So Lordship,
500
I'll keep it together. Learned advocate appearing for the state respondents seeks some more time to file.
একটাতেই দিয়ে দেবো না দুটো আলাদা আলাদা দেবো? আচ্ছা আচ্ছা, ঠিক আছে।
Lord, on the last day, Lord, I have
Yes,
concluded
yes.
my
That,
argumented point was,
I remember.
yes.
Yes.
Is there any other so-called notice for blacklisting? No, nothing.
Yes, Mr.
Lord, I have one instruction. Kindly handing over my lord.
If it is without show cause notice, then in that case, nothing.
Only one thing, my lord, some of the standard guidelines, my lord, what is the government is following that based on what the tender line.
Lord, tender condition.
No, tender condition will not do. You have referred to the tender conditions. The tender conditions which you have.
That order, my lord, which is one of the.
Lord, page 22 and 23 is the tender condition, my lord.
Where is the order? Tell me.
Order of punishment.
101.
101.
So that two pages short order. One of the reasons has been stated in the last paragraph, whereas it appears that the unprofessional attitude has caused the office resources and valuable time, putting the whole issue of public service delivery in the concern.
Lord, that is immaterial because, my lord, that is immaterial.
Even if this is there, before delisting, you have to hear them. Before blacklisting, you have to hear them.
We have focused there.
In show cause, this was not the ground. In the show cause, that is why on the last occasion, I remember. On the last occasion, show me.
Lord,
The show cause notice,
your lordship,
75.
Page 75, 70.
You have referred to clause 3, clause 8. None of these clauses.
Page 81 also another focus notice.
Yes, page 81 also.
81, your lordship, kindly, that is with regard to bad one. So-called notice 81. Lord, there are total 75, 76, 76A and 81. These are the so-called notices, my lord.
Page 81. Here also you have referred
Here
to
also
clause 8.
silent.
Clause 8 of the memorandum of agreement is something else. Show me clause 8. Where is clause 8? Clause 8 is at page 57. I have my notes ready.
Yes.
Page 57.
Yes, Lord. Page 57 is clause 8.
Contract.
Yes.
Time is the essence of contract. This is only this much. Where is the notice that you will be blacklisted?
Also, that is not specifically mentioned.
Has to be specifically mentioned.
No, this is not necessary, my lord. I am placing one judgment of the Supreme Court.
Memorandum will not do. You have to issue a show cause. Memorandum will not do, sir. Difficult.
In the clause 41, I have folded that page. Serial number 12. Procedure for suspension and debarment of supplier contractors. On the page, serial number 12 says one of the failure of the contract.
Very well. This I understand.
That is followed by my lord's queries are changed in the so-called notice that was not specifically mentioned.
So that blacklisting order is not one of the justified. Well, that is
How have you disclosed this notification was disclosed to him?
Nothing.
Then how will he know? Not right.
And you, and Lord, UMC Technologies Private Limited
Yes,
case,
they
Lord,
recent one.
focus notice was given, but there was no mention why blacklisting will not be. Lord, here there is a clause also. Lord, kindly look to paragraph 21, 25 and 26. Paragraph 21, 25 and 26.
Last time you had this, you relied on two.
2014.
Patel Engineering and Gorkha.
Lordship, 2014. Last time, my Lord, I have relied on before your Lordship, 2014. Lord, volume 9 HCC, Lord, that is Goenka Security versus Commercial. Lord, paragraph 33 and 34.
Yes.
Page 83, well, in our focus reply, they undertake to comply all these things. That is there.
That is with regard to, Lord, that is with regard to completing the work.
Page 83, response to our so-called
Lordship, there is a so-called notice, argument was advanced, paragraph 21, 25 and 26.
all necessary.
Page 83.
Page 83, also this is in the paragraph last line. We will undertake all necessary.
Which page? It is not legible.
No, that is
Legible
the,
is it's not
that
legible.
is immaterial because, my Lord, that against the tender conditions, my Lord, against the cancellation of the Lord work.
They have undertaken. They have
Yes,
not lived up to their undertaking. You will impose penalty. You will terminate the contract. That is all good. But blacklisting them is having civil consequences because they will not be entitled to enter into any contract with you for a particular period of time. It has a strong effect on the right to do business under Article 19(1)(g). It's an infringement of fundamental right that you cannot do without notice.
And Lord,
there
so
are
far,
several judgments.
and so far, my Lord, first part is concerned because of changing circumstances, another contractor was engaged and
Mr.
completed.
Banerjee,
Therefore,
it's only 4 minutes. I'll not be able to dictate order today. I am concluding the hearing and keeping it next Friday.
Lordship.
If you have to make any more submission, make. Otherwise, I'll dispose of.
Lordship.
Heard, learned.
আরে আপনি দেবেন, আপনি আমাকে দেবেন না, ছেড়ে দিন, আমি বুঝবো, মুশকিল হয়ে যায়, হ্যাঁ রাখে দেবো।
My lord, I am for the petitioners. Learned advocate Somnath Roy Chaudhary is unwell. I am praying for an adjournment, my lord.
Likhenin, an adjournment is prayed for on behalf of the petitioner. Full stop. List this matter on January 30, 2026.
Grateful, my lord.
Equal. Next.
Madam, appearing on behalf of respondent number 5 to 7, I'm led by Mr. Shonak Bhattacharya in this matter. He is on his legs before the Honorable Division Bench, Lordship. I'm praying for a day's accommodation.
Since Mr. Bhattacharya is there, I should not.
Next Friday then.
Grateful, my lord.
Third learned advocate, Likun. An adjournment is prayed for on behalf of the respondent number Friday,
It would be very
will
tight.
be there.
Yes. After vacation, my lord.
After we know, this is
Assignment or after vacation.
Very well. After only one week.
Yes,
Vacation is only 1 week.
Yes.
As prayed for by the learned advocate appearing for the
Prepared a report, not affirmed.
then affirm it in the meantime. 9 January.
So, Lord, kindly direct, Lord. I would file one supplementary report in the form of an affidavit and I'll serve a.
You bring it. I'm not passing it this judgment has been prayed to you.
Then why not kindly direct him to supply the report?
No, first I have
in
to
the form
write
of
before your lordship.
Let him come with the report. I'll direct.
Lordship.
I'll not pass any order without giving you an opportunity. Don't worry about that.
Okay.
Extremely grateful.
My lord, I am on behalf of the petitioner led by Mr. Firdaus Sami, my senior. My lord, there is a direction to file an affidavit in the form of court by the bank. Order dated 7th November 2025.
Where is the bank? Very well. It's 1:16 now. So maybe you are appearing for the bank. Nobody is there for the bank. Password করে রাখো 2 PM fixed হয়ে যাওয়ার পর যদি কল
Mayor is a kind leave to pray a small prayer before, although it is on the mentioning time. One contemporary also passed the order. There is a mistake in the cause title. I cannot complete it returnable on 8. Everything is all right. Cause title is different. In another matter, cause title has been impleted.
for correction.
Correct.
ঠিক আছে
আমি এটা
Supplementary paragraph also. Just a minute, there is a matter for correction.
I have seen the order.
The wrong order was uploaded. Correct order was there in file because there were several extension of interim orders on that day. This is the order. This matter is appearing at the instance. The parties are represented openly. नाम लिखे दो मुझे. Because the entire cost title is of somebody else.
Even the appearance is the somebody else.
If appearance is also somebody's. The body has been pasted there. এটা ওর ভেতরে রেখে দিই. ভেতরে রেখে দিই. Thank you. I was also astonished. How could this happen? Because several orders were there. Anyway.
In item number 1, Mr. Das is appearing as a respondent number 2. Due to his personal difficulty, he is not appear in this court today, Lordship. So I'm
Right.
just because his death, father death anniversary today. That's when he not came before this court, Lordship. So if the Lordship fix the matter on next
Basically,
week,
my submission, my lord, and based on Supreme Court judgments, and so really not that he can take notes, whatever, and I will give copies of the judgments.
if he can do.
But my lord, you know
And
my
on the
argument.
next day when he submits, you will also be present because you may be required to reply to his submission.
Yes, yes,
Look,
I will be.
I'll hear to him so that we proceed a step further. A step further. Yes.
Yes. So, my lord, today, your lordship last day's order says that to show how NCDRC would be a party.
Necessary party.
Necessary party. And my lord, during this break, I was just thinking about this matter, and then I thought, so what was the situation? Just one step back, I came before your lordship with that petition, writ petition 226/227. And they came here, they say, no, Article 12 should be the Shalini, the Supreme Court Shalini judgment. But then, exactly that submission, according to what they said, when I wanted to add NCDRC, now there is objection. No, the Article 12 should not be used here. Yes. It should be 227. Yes. So the question came to my mind, we want a fair, impartial, neutral judgment on merits. I had no objection also on 227, my lord. The only reason, your lordship knows, that I did not select this bench. This was assigned here by the High Court.
Because
but,
226, if
yeah,
it is written,
right.
it will come to 226.
No, that's fine. But I had no role in that. But when I came
and they wanted Article 226, which I mean the Article 12. Now they objecting. No, that is not what they claim, but they made claim before Lordship. So I was just wondering that what could be the reason? They must be wanting like what I want here on merit and a decision. So my only problem is 227 at this stage only. To go back, it will be reassigned to another bench. And then I don't know. I mean, that bench may be amenable to me and consider quick hearing, maybe not, knowing I've been doing my list. So that's just a thought came and very bothersome, my lord. But then I will follow what your lordship passed the order last day. In fact, I will start with Shalini. I mean, I read and reread that. And I'll just show you just one part, what they have relied upon. On Shalini, paragraph 49, just that I will show what the very same judgment says. Your lordship got that page 19 on the top. This is what they gave. So this is only LMN. I'm going to read only these three subpara. You wanna got that?
Page 19.
Page 19, yes. It starts with I, F, K, L, M, N, so on.
Page 19 of Shalini.
Yes. That's the one they gave. My lord, this is the same copy they gave to you.
No, I have an SCC on SCC copy.
Oh, whatever they gave me a copy of what
That is page number 348.
348.
Where's the
Internal
348?
page, lordship 20. Internal page is 20, lordship.
No, no, I
The upper heading.
এটা তো আপনারা দিয়েছেন এটা 19 আমি দেখছি only thing. ALMN. That's not 20. Where is 20? 19, I think.
This is page 20.
But here, okay, fine. Your lordship got that.
Yes,
So
on a proper appreciation, this sentence begins with that.
no, it begins L.
L
Yeah,
on a
okay.
proper, on a proper
K is the power is discretion. So I'm reading
L is on a proper appreciation.
On a proper appreciation, yes, your lordship, right. On a proper appreciation of the wide and unfettered power of the High Court under Article 227, it transpires that the main object of this article is to keep strict administrative and judicial control by the High Court on the administration of justice within its territory. The object of superintendence, both administrative and judicial, is to maintain efficiency, smooth and orderly functioning of the entire machinery of justice in such a way as it does not bring it into any disrepute. The power of interference under this article is to be kept to the minimum to ensure that the wheel of justice does not come to a halt and the fountain of justice remains pure and unpolluted in order to maintain public confidence in the functioning of the tribunals and courts subordinate to the High Court. Then the important one, this reserved and exceptional power of judicial intervention is not to be exercised just for grant of relief in individual cases, but should be directed for promotion of public confidence in the administration of justice in the larger public interest, whereas Article 226 is meant for protection of individual grievance. Therefore, the power of under Article 227 may be unfettered, but its exercise is subjected to high degree of judicial discipline pointed out. My lord, this is a case. It's an individual grievance. Exactly that, my lord. Wrongful death due to medical negligence. So even this, what they suggest, this type of cases, but this type of cases back then were not under any writ petition, so no history of that. But the very observation made here makes it clear that even Shalini, had they seen this case, they would have said this should belong 226, not 227. So, my lord, the other point for 226, here, I will show your lordship. There's no dispute, no question on facts in my writ petition. It's only on the question of law, my lord. Pure and simple. I will just show you a little bit why I'm saying that. That there is no question disputed on the facts of the case, but what's the order of NCDRC is legally it's flawed and ex facie it's flawed. My lord, if I may just show you one small part, just what I said in that petition, my lord, in my writ petition. On page 5, paragraph 6. That's in a nutshell why I am before your lordship.
Page 5, paragraph 6.
Yes.
Yes.
That while dismissing a so and so filed by the writ petitioner, complainant, the learned NCDRC clearly agreed with the primary contention of the writ petitioners herein and rejected the sole legal principle based on which the learned SCDRC had denied the review application. So how? Let me now go to page 18. That's where they quoted, this judgment quoted the whole SCDRC judgment. So why I'm saying it's only pure law. Page 18, my lord. Order. Page 18. I have annexed that thing. Order, second para. So this is the order which I have challenged. So second para. State Commission considered the review application filed under section 50 of CPA 2019 and held that it could not be considered and dismissed it at the admission stage. The State Commission has held as under, quote, so that's from the State Commission judgment. The provision under section 22(2) of the CPA 86 clearly connotes that without prejudice to the provisions contained in subsection 1, the National Commission shall have the power to review any order made by it when there is an error on the face of the record. So it is crystal clear to us that the State Commission has no such power to review. My lord, this is the ground they dismissed my review. They say, oh, because this case is old, back then 1986 Act. But when it went to that stage in 2022, 2029, the 86 was repealed, 2019 Act came into force. And under that section 50 clearly says State Commission should review, has the review authority. So why they dismissed my case? Only one ground that, hey, this was filed under 86 Act. So we cannot review in the year 2022. Now, that is the wrong assumption and which is agreed by NCDRC. I will now follow the next page. We'll continue on the next page. What then they say? So question preferring review invoking section 50 of the new act does not arise at all. Practically, the review applicant have no locus standi. They didn't look into my on merit. They say I have no locus because my original petition, since it was filed in 2013 under 86 Act, so they cannot see it under 2019 Act, section 50. That is one and only ground my case was dismissed. On the next page, page 19, prefer review application on the strength of section 50. So that's what they say. Then let's go to para 6. Para 6, just few pages down. That is also part of the impugned judgment I have challenged. Page 20, para 6.
Short issue.
Yeah, the short issue before us is whether the dismissal of the review application under section 50 of the Act by the State Commission was in order. So this is, the judge also said the same thing. What I just said, that was the only reason, one and only reason. It is apparent, then they're saying, it is apparent The appellants had filed a review application under Section 50 of the Act. This section reads as under. Review by State Commission in certain cases, the State Commission shall have the power to review. So what I say, so they had the power. But they said, no, we cannot because 86. Then, para 8, while it is evident from this section that State Commission shall have power to review. So they agreed with me, my sole contention, that State Commission was wrong, but they have the power to review. So, my lord, it is a case res ipsa, my lord, speaks for itself. I don't need to go into any argument, any discussion. All I said, they were wrong. We can file under Section 50. So remand it to State Commission to pass an order on merit. That's all we have here, my lord. Because that bench made such error, which only that bench can fix. Akram Ansari said, if we raise some point and court didn't write it, then you must bring before the same bench. I've relied here, I've given that Akram Ansari, very well known now. So I had no option. I could not file the case to the appellate authority, NCDRC, until and unless those things were corrected, which those bench and only those bench, nobody else, could correct it. I'll give an example, what kind of, I can show, we have given the review petition. I'll just tell you for sake of time. So this is a medical negligence case. The case, a doctor who died is a doctor himself, dermatologist, well-known professor, had a head injury, fell down, taken to the nursing home, and left there in the nursing home overnight. My lord, this doesn't need much medical knowledge, but I'm a doctor, I can tell you, the golden hours, it's a rule. Head injury cases, my lord, the most important, what is the fear? Internal bleeding, my lord, which you cannot see outside. But if the bleeding, you let it happen, then they will crush the brain. That brain is, so that basic cardinal principle, my lord, is that do a surgery, take out the hematoma ASAP. And that's a common sense thing, my lord. You can appreciate, my lord. Head injury patient, so they left it there without a CT scan. Even they look if it's bleeding or not. Any patient, even if there is no bleeding, when it comes with a head injury, they should do that. Because that's the only way they may die otherwise, if it is bleeding in the brain. And my lord, that judgment, that State Commission dismissed it, saying that, no, there are some papers saying it is better to do delay in head injury case, which is just on the face, it is absurd, my lord. I've written to NMC also, because this may, if a new doctor, young doctor read that, they say, hey, the court said you let the patient do surgery later. It's unthinkable, and more people would die if that is followed by anybody. But we raised all these issues in that review petition, which was dismissed, my lord, solely on that question that they don't have, I don't have locus because they cannot follow 50. Now, which was overturned, said exactly opposite, NCDRC. But then they dismissed my case anyway. So that is why, my lord, we are here. But I will not stop here because your lordship said to show NCDRC could be a party. I will show that. And let me pass you on. Now, my lord, this Faizan, the judgment they relied upon, this is a very new thing.
I have Faizan, I have.
Faizan you have. No, I'm not giving Faizan. Of course, I know. Our petition also has Faizan. So, what happened? Supreme Court in Faizan for the first time in 23 SCC said that you file a writ petition in the event it's an appeal which was dismissed by NCDRC. But if original jurisdiction NCDRC dismissed, Then you come to Supreme Court. That's, your lordship knows that in this case and maybe other cases. So it's a very new decision, relatively speaking. And since then, since Faizan, there are only two Supreme Court judgments relating to this question, writ petition. One is Sompo, which is much well known later on and much bigger, elaborate, where it repeatedly held that it could be under 226 or 227. And then only one other judgment, 2025. Your lordship, you have given that judgment also.
Yes.
That PGI. There it says only 226. So only 3 judgments so far. But there are also very few cases, writ petition filed, that I could search and get it, like our position, but there are some in different high courts. So that's the one I have given a copy of that. The first one, I realize this is a Messrs. Creation Associate, Bhubaneswar, versus Registrar NCDRC and another. Your Honor, you see that. And notice here, so this writ petition challenging an NCDRC order, exactly what we have done. And they made NCDRC party. In fact, you see the opposite party who appeared for NCDRC? Mr. P.K. Parthi, so Deputy Solicitor General of India. They went there and argued this matter. This matter, the merit doesn't matter, but it's a matter of landlord and purchase of a flat. So, but that is not relevant at all. It's the principle which is relevant. So, NCDRC appeared before the High Court and argued. So, they appeared. Now, they had nothing at stake themselves. But if there were some error which is apparent, they could have corrected that. They would have, and they should have. Now, in this case, they argued in favor of NCDRC. This was a delayed. They dismissed on delay. And they argued in favor. So the High Court went into the merit of this case, my lord, and then passed a final judgment dismissing that review petition. If you, I only show 2 paragraphs here. Paragraph 18. That is towards the end, my lord. Page 13 of 14 in the bottom.
Yes.
The NCDRC observed that the petitioners failed to offer a sufficient explanation for the considerable delay in filing the revision petition. While the petitioner filed 2 miscellaneous applications, then I'll come to the middle. NCDRC correctly concluded that the delay application lacked merit. And this court concurs with that assessment. The petitioners have failed to offer a reasonable explanation for their inaction, and therefore the delay cannot be condoned. Upon careful scrutiny, it is clear that the petitioners have failed to provide any justifiable ground for the significant delay. So, my lord, High Court, after hearing argument by NCDRC, the Solicitor, Deputy Solicitor General, came to this conclusion. So, NCDRC is a party, necessary or proper party. And I will show you some Supreme Court judgment, what they say about this, necessary and proper party. But here is an example, very few examples are there, where exact same scenario happened and NCDRC appeared. Not only they made a party, they appeared and they argued, my lord. And against this, the second judgment I have given, pretty much same one, they filed a review. So I've given that one also, the Orissa High Court. Your Honor, got that? So they challenge that observation, which I just read before the same bench for review.
Yes.
And only, I'll just read a small part of this. Basically, what NCDRC says. On page 5, so they heard the review on merit again. Submission on behalf of opposite party, that is NCDRC. So they heard them, and towards the bottom it says, quote, reasoning. Yeah, 3 p.m. maybe, because
3 p.m. original segment.
yeah, I'll try to be as short. I'm skipping something, but this is a question of law.
Your matter after vacation. Not this.
Yes, yes. Sometime I will try to be as I don't want to waste time, my lord. You know, court's reasoning and analysis. Paragraph 6. The present case concerns the petitioner's challenge to the decision of the NCDRC, which rejected petitioner's application for condonation of delay in filing a revision petition. So that is what the court analyzed. And then very last page, paragraph 14. The court has analyzed on merit. In the present case, the delay in filing revision petition spans a substantial period of 428 days. The petitioner has asserted that there was sufficient cause for this delay. Yet, the record reveals a pattern of inconsistent conduct throughout this period. Despite the significant delay, the petitioner has failed to offer coherent and compelling explanation. So then on 18, they say the petitioner have not demonstrated any error on the face of the record in the judgment. The decision then they dismiss. My lord, I just showed you the judgment which I have challenged. And that error, I just showed you that court said, no, they have power under section 50 of 2019 Act. Clearly, it is evident. And the undisputed fact, they dismissed it only on that ground. I have no locus. High Court judgment. Very similar situation. And that's a division bench, Madras High Court. It's writ petition 10749, 2024. This is against a realtor property builder case. But again, the main OP, number 1 OP is NCDRC. And they appeared, it's recorded here also. And the court heard at length on merit, then eventually dismissed against that writ petition matter. So it's just on page 1, yeah, if you just see the page 1, very next page, I mean, page 2 actually, it says prayer writ petition filed under Article 226 of Constitution of India, seeking for an issuance of writ of certiorari or called records relating to first appeal number so and so, dated so and so, on the file of National Commission, and respondent NCDRC. And this is the order. Again, they dismissed this condonation of delay. Basically, again, there's no reason to go into the detailed merit of this case because the case, lower court, state commission dismissed condonation of delay. NCDRC did that too. So, my lord, now I have passed on, I think, 3 Supreme Court judgments. That's on the question of necessary/proper party. The first one is 2010 SCC. It is Mumbai International Airport Yes, very well known, very well known judgment. Now, I'll just take your lordship to para 13, few paragraphs, what it says. The general rule in regard to impediment of parties is that the plaintiff in a suit is dominus litis, may choose the persons against whom he wishes to litigate, and cannot be compelled to sue a person against whom he does not seek any relief. So, my lord, that is, I have a right to choose. I could have done it at the beginning or now. Consequently, a person who is not a party, the other side, has no right to be impleaded against the wishes of the plaintiff, but this general rule subjected to that order 1 rule 10. My lord, very well aware of that. Then 15, the next page, not 15, a necessary party is a person who ought to have been joined as a party and in whose absence no effective decree would be passed at all by the court. If a necessary party is not impleaded, the suit itself liable to be dismissed. A proper party is a party who, though not a necessary party, is a person whose presence would enable the court to completely, effectively, and adequately adjudicate upon all matters of dispute in the suit, though he need not be a person in favor of or against whom the decree is to be made. My lord, so here I have already shown your lordship. The NCDRC could be at least a proper party, because their presence will help this honorable court that why that kind of, and they may retract it. They will have, if they appear and an answer, and I hope and I think they will, my lord. But if they are not allowed at this stage against my right to implead, then I may have to come back again by impleading them as a party, a separate writ, because I think their presence will be important in view of the fact that, yes, you cannot rejudge the facts, question of fact, that's the trial court. But I showed you our main contention is a question of law, pure and simple law. And that's the only reason they dismissed my case, the review application. Then paragraph 24.4. Citation, yeah. 24.4. That's page 12 on that one. If an application is made by a plaintiff for impleading someone as a proper party, subject to limitation, bona fide, etc., the court will normally implead him. So that's, the court should allow my prayer. If he is found to be a proper party. On the other hand, if a non-party makes an application seeking impleadment as a proper party and the court finds him to be proper party, the court may direct his addition as a defendant. So court can also do that if they say, but there is a caveat after that. But if the court finds that this addition will alter the nature of the suit or introduce a new cause of action, it may dismiss the application even if he is found to be proper party. My lord, so Honorable Supreme Court distinguished between plaintiff and defendant. In their case, if they wanted to bring NCDRC, that is one scenario. But when I am bringing, this court should allow this, my lord. What in this Mumbai International Court says. A later judgment, similar point, emphasized 2022 SCC matter. I have given this one, Sudhamai Patnaik and Bivu. So only paragraph 9. Paragraph 9, you want to got that? So at the onset, it is required to be noticed that the defendants in the suit file application under Order 1, Rule 10. So in that case, actually, the defendant filed it. But anyway, in the next sentence, as per settled position of law, the plaintiffs are the dominus litis. unless the court suo motu direct to join any other person not party to the suit for effective decree and or for proper adjudication as per order 1 rule 10, nobody can be permitted to be pleaded as the defendants against the wish of the plaintiff, against the wish of the plaintiffs. So, my lord, there's a distinction in this case as a plaintiff and as a respondent. I have lot more leeway, my lord. Repeatedly, Supreme Court said this. Therefore, subsequent purchaser would not have or not impleading here. The next sentence is important, my lord. Not impleading any other person as defendants against the wish of the plaintiff shall be at the risk of the plaintiff. My lord, so if your lordship feels now they should not be added, then I will be at risk. That is not permitted. Supreme Court said this. And the latest on this, just earlier this year, I submitted 2025 SCC. So here, this on page 13, very bottom, it's a long judgment. I'm not going to read whole thing. Page 13, very last paragraph. It starts with essay 13. From the aforesaid discussion, so they discussed all these matters here. It is pellucid that necessary parties are those persons in whose absence no decree can be passed by the court, or that there may be a right to some relief against some party in respect of the controversy involved in the proceedings. And proper parties are those whose presence before the court would be necessary in order to enable the court effectually and completely to adjudicate upon and settle all questions involved in the suit, although no relief in the suit was claimed against such person. So that's exactly what I want. I don't want any decree against NCDRC, but to help this honorable court to come to an equitable and just decision, my lord. Their presence is necessary. And then, and they have analyzed that all these judgment very well. It's a long judgment, but on page 16, para 29. I got that? Para 20. It was observed that the court may exercise discretion in impleading a person who is a proper party upon an application by a non-party to the suit for specific performance. If the court is of the view that the impleadment of such proper party will alter the nature of the suit or introduce a new cause of action, it may either refuse to implead such person or order for his impleadment on certain conditions. However, even otherwise, the court would not be precluded from impleading a proper party unconditionally. So you are not precluded to admit a party, proper party, unconditionally. Or you can impose some condition. That's that order 1 rule 10. The relevant observation rendered in Mumbai. So they rely on this thing. 24.4. If an application is made by plaintiff for impleading someone as a proper party. Yes, right. In fact, I read this thing. The point is the sister redecisive, so they relied on that observation. The court would normally implead that line on the third line. That's the only reason, my lord, I brought this. So, my lord, at this stage, I think it is only proper and just to have NCDRC come here and argue why they passed that order. They may defend, they may say there's nothing wrong. Then, of course, your lordship will judge on the.
It's not required to argue in support of the order that it has passed. It is not required to defend its order. If, for example, if the court, there are courts higher than the court, there are courts lower than the court. Now, if an order passed by a court is challenged before the higher court, you did not add the court as a party to the question, or to the proceeding. And the court is not required to come before the higher court and defend its order, saying that I have passed the order by order right. Because the court is supposed to be an independent body.
Yes.
It becomes movement
Yes. I can appeal, I can challenge, but I cannot bring the court. I totally agree. This is, but there is a difference, my lord. No, but there is a big difference. That is that Pfizer, then Sampo, Supreme Court compelled me to come here, my lord. So and said, Article 226.
Because both have been mentioned, one may be applicable, the other may not be applicable. In a case where 226 applies, we have to share all whether all the parameters which are required for a 226. I have been sure.
Yes.
The moment you put all the parameters across the threshold, 226 becomes mandatory.
Yes.
But
So, my lord,
sort of that.
Yes, but I have shown just now, even Shalini itself says a individual grievance should be 226.
No, individual, it can't be that not individual, it will not be entertained, but if the individual can show that it is of public importance.
So it is.
Now the points that you are raising, or the point raising difficult for groups before whether I are all points of law.
Yes.
Every point of law has a bearing on public life in some way or the other. For example, that does not have and should have taken as for the court, and therefore it should have to be continued for the life of the earlier act and not in the life of the later act. So this is again a question of law. This decision is going to have a bearing on the public. So that we also for appropriate. But although you are going to be benefited by the order, but this is not only you who is going to be benefited, but it will public has have to be benefited one way or the other. The mandate is different.
But my lord, my humble submission, my lord, I showed you number of judgments by other high courts division bench. They have taken NCDRC appeared and argued. And so under 226, not 227. Dr. Shah, yes.
If an objection is not taken as the court that will not be binding on because that is not ratio. First of all, none of these are laying down any law that NCDRC should be a part. Yes, people had added party, court has taken it, but I have also noticed that no that the objection was taken. The moment an objection is taken, for example, I was educated if this objection had not been taken as regards to private party and all. I might have missed it, I might not have missed it, I don't know. But if a court misses that and passes an order, that will not be a binding unless it satisfies the dicta of the order.
Delhi High Court order. My lord, yes. Yes. Then they say 2 to 6 or 2 to 7. That, yeah, they have not defined that. I agree. Yeah.
So this is a very strong statement by the Honorable Chief. We cannot ignore that. We are bound by it. All of us are bound by it. It's the law binding on the nation that 226 must be directed against the article 12. Because that is the statement. I state that all various
227. Yes. 226. Yes. Yeah.
That's a very strong line. We are absolutely bound by it. We cannot even move an inch beyond that. Whatever is that is the law.
Then how do I submit it 227? If you agree with that view, that it should be 226, not 227.
No, but one of the responsibilities and yours demand say now here suppose the ultimate order will be passed in your favor and against the party. It is valid as a respondent before the national commission or before the workshop. The order will not affect the national commission or the workshop. Their order will be set aside because they are not attached.
Right.
The order
Yes.
will be affecting
Yes.
the person who is attached.
Yes, yes, yes.
They are deciding body, they are independent body. So any order passed by this court is not going to affect them. The incidence of affectation is deciding who is the party against whom the order is directed. Now, if your order was directed against NCTRC, then in that case you could have said yes, which is the proper party.
And the SCDRC, both that I do.
I'm only adverse that side your that will not affect NCTRC. If I had suppose there was another type of an allegation by affecting directly the person, then in that case, yes. But this is not the case.
And so who can say that, my lord? NCDRCs only can say that in their view when they appear. So for a fairness, my lord, and for argument, otherwise it will extend. But if NCDRC appears here and admits and takes it back, then now this is all new, my lord. Only very few. Here is one thing I thought I will not give Delhi High Court. This is another case, but I tried to answer what you wanted to know, the NCDRC. Now here is another case. Very few cases happened till now, since the 2024 decision that. So my lord, what is in this matter? It's again a consumer NCDRC, the same scenario, and here, if you see on page para 13. No, para 227, my lord. That's the background of this case. And then the only one I wanted, the background is again, this is a case of some property thing. But so the history is para 227.
27
No. History is 227. From 2 to 7. That's the detailed history.
Para 8. Para 8.
Yes. Yes, para 8. The one I want to draw your lordship's attention, para 8. A perusal of the order dated so and so reveals no error apparent on the face of the record or any infirmity warranting interference in these proceedings under Article 226 of the Constitution of India. So here is another judgment. There, NCDRC was not made a party between two private parties. But the Delhi High Court dismissed it on merit. So what if this case, this could. So, but if your lordship decides that no, I cannot, it will be only 227, that can be filed under 226, then all these judgments are per incurium. I mean, not bound, but proposition of law, my lord. Then it is per incurium if they have done something against Supreme Court. But in my view, they did not. But after SOMPO and after PGI, 2 decisions of Supreme Court out of 3 categorically said, one said only 2 to 6, one said 2 to 6 or 2 to 7. Yeah, that is. Yes. Now, OMAXB is the only one which is clearly did not even coming to the discussion of 2 to 6. They only keep on saying. Yes, I have seen, but I've seen that, but there is nothing. Calcutta High Court, but I gave your lordship Rajasthan Division Bench High Court, and that. You have to distinguish all these observations of judgments I passed today, that they all are done 2 to 6, and they made. Yes. No, I very much appreciate this, but no. This is the good nature of your lordship. But what I am saying, but in my case, there's no medical negligence case, except that PGI, my lord, Supreme Court. Other cases are all landlord and property. So the right to life is not involved at all. But in my case, my lord, I said this, I will say again, that even on that ground, Article 21, a patient died allegedly due to wrong treatment. So his right to life was taken away, protected under Article 21. I cannot file 2 to 7 claiming that. They will say, yeah, go to 2 to 6 for individual grievance. So, my lord, till open a Pandora's box, my lord. What will happen? So one court will say this, other court will say exactly opposite. Now, no court yet said you cannot file under 2 to 6. At best, some courts, in a sense, but not, it's not explicit, my lord. They didn't mention 2 to 6 at all. And then the follow-up judgment will be the President, my lord, SOMPO, and the PGI. Two. Following OMAXB. And in fact, they argue OMAXB the circuit. SOMPO is an elaborate. So you follow, which is binding on this court. And they say repeatedly 2 to 6 or 2 to 7. Yes, but you are not letting me that. If you dismiss my this petition now, at least oral submission, that let make NCDFC, that's all. And I just read today, Supreme Court said it's a proper party. If the plaintiff feels so, High Court should allow that. And they don't have any right.
You will come Monday, lordship, but
my lord,
then lordship,
yes. Not this month. Well, I have to extend my stay, my lord. This is the thing. The video. So next week, January, my lord, I am as I told your lordship, I am doing this for so many people, my lord. I am doing many cases, my lord, across India. No, I'm telling you, I let me, no, I don't want to, because only thing, I mean, look, as I said, I could have easily say, okay, let's go file, take it out and file. No, my lord, but it will not be, time will not be helpful. At least, no, this issue came up only 2 days ago. So, my lord, they didn't raise this. I said, your lordship must think this. They didn't object to this. They said, oh, Article 12, you add. And now they're saying, no, I cannot add Article 12. Even so many cases they have. NCDRC is the main respondent, and Solicitor General appeared. So my lord, January, my lord, say 1st January, of course. 4th January. 4th. Oh, 4th is Sunday. 8th. 16. Then 10th is what day?
Saturday.
Solo. Oh my God, yeah. Because as I said, Your Honor. Yeah, 16, I see, because all these cases are prefixed that I appear and I travel in India. 16. No, 9th I have a final hearing, long fix. 16th I can, but that is 1 month, my lord. Your lordship can't. I have to have come this far and for this matter. And this is an important question. There are many cases this will come up, as I showed your lordship, but very few right now. And all the one where there is a judgment, they are on in favor of us.
I was
Ma-
not replying. Let's say my report was ready. But no, yes, already taken. I only was seeking the notice of its accommodation further because oh, that by that time it will be fine. Obliged. Obliged. Board application, item number 2.
My lord, I am praying only not to do, my lord.
My lord, then kindly. My lord, then item number 3, 4, 7, and 8 are connected to item number 2. My lord, it's come from the same impugned order. My lord, it may keeps it on Monday. My lord, I think Mr. Obrotosh Mujumdar is the lead person who's leading all of us. My lord,
Monday group 4.
he will be there Monday.
ওখানে তো সেকেন্ড হবে আপনি সাইড নেবেন না সেকেন্ড মানডে আমরা বলে দিই মানডে হবে না
Might be on Tuesday, my lord, instead of Monday.
It's no problem.
Tuesday না
ব্যালকি ব্রিফ প্রতিদিন
after vacation.
My lord, then keeps it after vacation. I think
Because it's getting delayed without.
my lord,
After vacation should be fine. I've conferred with the. Yes, yes. Yes.
আমি দিয়ে দিই 7 আছে ও আবার 1 তারিখে যাবে আমি কি করবো এখন
দিয়ে দাও 2, 4, 7.
4 এ তো কে আছে আপনি আছেন জানি না এই রে No, my lord. But our appearance to be recorded because department will say why we have not appeared.
No, these are not counted. And the department will further say why you have taken it.
They are effective, non-effective between these, my lord. Here.
Yes.
Item number 5.
My lord, I'm led by Mr. Sachin Jhamwala. I was humbly praying for a short Passover month.
Item number 6.
I am for the one of petitioner, my lord. Your lordship kindly keep it after 7 days because my lord, Mr. Farooq Rajak, I don't know when he, after 7 they need it. Petitioner. After 7 they need it. Right.
Item number 9.
And for the petitioner, lots of the respondents have informed us that they want to do it on Monday. They have Miss Manushi, but Mukherjee was appearing. Your lordship.
Item number 10.
My lord, in this matter, I'm led by Mr. Bipul Kundelia. He has a fixed matter before court number 32. I'm praying for not today, my lord.
Your Lordship, in this matter, Your Lordship had called for a report. Mr. Banerjee, Mr. Bhaskar Prasad Banerjee. He's not. Some. And yeah. It has been served, Your Lordship.
But 13 May can you paid off today? He could not come on the.
I'm praying for a Lordship.
15. But after vacation. Much of this. 15, 16. Item number 16. 16. Same. 15. Item number 17. 18. 19.
Khan is appealing for the petitioner. Yes, sir. Malad, ki fix it or some other day, Malad? Monday, Malad, I have lots of matters because it's happy. I had only one Malad here. Now he is planning to try for service.
By night.
Malad on Tuesday. Because Malad on Monday, what time the second half? Yeah. Number 20, 21, and for the 22.
At 23, when I'm appearing, my lord, in this matter, Your Lordship, actually, in this matter, Your Lordship, the proceedings under section 148 have been challenged. Your Lordship, what has transpired in the matter is that, Your Lordship, that in this case, Your Lordship, the company has undergone CIRP proceedings.
For the revenue.
But this matter is being called for the first time, Your Lordship. I'm not.
There is no representation. Actually, you are nearing closure now, so maybe.
My lord.
People have left. I'm making it not today.
My lord. I'm grateful, Your Lordship.
25, my lord, I am appearing virtually, my lord. I am praying, my lord, time, my lord, kindly fix it on Tuesday, my lord, on 16th, my lord.
Likhanin, as prayed for by Mr. Dugar, learned advocate, appearing for the petitioner. List this matter once again on December 16, 2023.
I'm grateful, my lord.
25 and 26.
Both, my
25 and 26.
25, 26, same order.
Same assessment.
Yes.
Well, in this matter, giving Mr. Dutt's name is unlike by Mr. Dutt.
I'm grateful, man.
Thank you.
28, 29.
29, I am for the petition. I am paying not today, my lord.
Not today.
Deep lord.
31, 32, 33, 34, 35,
Your Lordship, in 35, I am praying not today.
37,
Call. 38.
Miscellaneous matters. Item number 38, 39,
The 39, my lord, I appear on behalf of the applicant in GA1, my lord.
You are appearing for?
My lord, GA1 is my application. I am seeking intervention in the writ petition, my lord.
You have served copies on the other side.
I have served copy, my lord, upon the petitioner as well as upon the High Court administration, my lord.
Nobody is appearing.
My lord, there is a duty upon my part to appraise, my lord, this concerns appointment of an official before the High Court, my lord. However, what I have been learned that at point in time, my lord, at some point in time, that concerned official used to serve as a officer before this honorable court also, my lord, at times. So it's my duty before the court to appraise your lordship in this regard. That is the only reason I'm indicating, my lord.
I couldn't get you. Please come again. What did you say?
My lord, the applicant in GA1,
yes,
my lord, happens to be a officer of this court also, my lord, before your lordship. At times.
Very well.
If your lordship be pleased to fix any day, my lord, I'd be.
Likhun. Any day means before the vacation. I don't think I'll be able to reach again. Today was a chance.
My lord, in that event, my lord, if I'm allowed to place, my lord, my case.
The other side is not there.
Like I can understand, my lord.
None appears for the writ petitioner. The respondents are also unrepresented. Full stop. The applicant in GA1 of 2025 is present. Full stop. For ends of justice, list this matter once again on December 19, 2025.
Grateful, man.
Friday, specially assigned to Friday.
code application under unauthorized documents, item number 40. Code application, item number 41. 42.
I am for the response. Old back.
43. 44.
Your Lordship, I appear for the petitioner in 44.
44.
Yes, Your Lordship.
What do you want to say, ma'am?
Your Lordship, I'm just requesting to fix a date and time for the arguing counsel to come and appear before this court. Like any day and time may be fixed. And in the interim, the stay may be extended, which was
He
granted
is
on the
already there, I
previous day.
think. It was extended until further orders. If no order is passed, it will remain.
All right, Your Lordship.
Not today.
Your Lordship may fix a date.
It is there in the list, madam, whenever it is called on. Fixing of
Your
date
Lordship,
before the vacation, fixing of a date may not be possible. Let us see.
Your Lordship may fix a date after the vacation since the arguing counsel
That
is
will
from
decide
Delhi.
after the vacation if I retain determination. I don't know.
Noted, Your Lordship.
For arrest, item number 45.
42 देखिए রিলিজ করেছি 42 হয়তো পড়ে থাকবে लिखे दी। This matter stands released from this list on my personal ground. Stop. Let this matter be placed before the Honorable the Acting Chief Justice. The other one I had not appeared, 41. To 41 টা check করে নিন তো। At times for Union of India, I don't know. नहीं ठीक है চলুন। থাকলে উকিল বাবুরা বলে দেবে যখন ম্যাটার হবে তখন দেবে।
Matter motion item number 46.
চলুন
47,
ফার্স্ট ওভার করে যাচ্ছি।
48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, for hearing group 1, 60, for hearing Calcutta documents 61, for hearing group 2, 62, for hearing group 4, 63.
My Lord, Bhaskar Singh Gupta is appearing in this matter. I'm praying for not today.
Not today.
Grateful.
64, 65, 66, 67, 68, 69, 70.
Should I record something? Not today.
71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86,
এই 80 টা একটু দেখুন।
91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108.
Your Lordship, in item 108, Your Lordship, I'm appearing virtually. Your Lordship, there is just one humble request in the matter, Your Lordship. Your Lordship, this matter was admitted by an order dated 27th October 2025, Your Lordship. Your Lordship, the time to complete the assessment is coming to an end, Your Lordship, on 31st March. Your Lordship, the department is yet to file their affidavit in opposition. My Lord, if a date may be fixed, Your Lordship, even in the month of January, Your Lordship, at least I can then pressurize the department to quickly, my Lord,
It's
file
there
a
in the
copy of the
list.
affidavit in opposition.
It's
But
there
my,
in
my,
the list.
actually, my
Who is
limitation will
appearing?
expire.
You are appearing.
Mr. Prithu
Who is
Duduria had
there also
appeared.
for the department?
Mr. Duduria had appeared, Your Lordship, at the time of admission.
What was
I'll-
the order? You are not enjoying any stay.
Well, actually, the stay is such that I will have to participate in the proceedings. The order will not be given effect to. But
So
Your
that's
Lordship, this
good
is
enough.
clear. But Your Lordship, this is a
Won't
clear.
hurt till it reaches.
But this is a clear case of change of opinion, if I may submit, Your Lordship. It is a very clear case of change of opinion.
Then
It will not take
once we reopen, we'll take stock of this. We'll start taking hearing matters after reopening. So
My Lord. I'll trouble my lordships after
yes,
reopening.
sure. No question of troubling. It's my duty.
My lord.
I'll do it.
My lord, one Indian
I'm
is
grateful,
item
my lord,
number
I'm grateful.
103, my lord. We are for the respondent. There is a direction for filing the affidavits, my lord. Time has expired. My petitioners are here. If your lordship extend some time after.
File their opposition.
Extend some time, my
I'm
lord.
granting them extension. How much time? 2 weeks?
2 weeks, let it fix after vacation, my lord.
Very well. 103 তে একটা order record করে নিন। হ্যাঁ 10
Grateful, my lord.
Estroso Technologies.
Estroso Technologies.
Ms. Chaudhary appears for the petitioner. Full stop. Mr. Bhonjo, learned advocate, appearing for the appears for the petitioner and submits. Ms. Chaudhary appears for the petitioner and submits that Ms. Chaudhary, learned advocate, appears for the petitioner and submits that despite directions passed by this court, no affidavit in opposition to the writ petition has yet been filed by the respondents. Mr. Bhonjo is led by Mr. De. Full stop. Mr. De, learned advocate, appearing for the respondent, customs authorities. Yes. Customs authorities seeks extension of time to file affidavit in opposition to the writ petition. Full stop. As prayed for by as requested by Mr. De, comma, let affidavit in opposition to the writ petition be filed within 3 weeks from date. That will take us to after.
And
Reply thereto, comma, if any, comma, may be filed by the petitioner within a week.
2 weeks.
Within 2 weeks thereafter. Within 2 weeks thereafter. List this matter for hearing immediately after expiry of the time fixed for exchange of affidavits, as above.
Grateful.
Lord, before my lord rises, Lord, may I have my lord 60 minutes? Well, I'm sorry, my lord, I joined late. My lord, I had item number 39, where, my lord, I was representing High Court administration. My lord,
Yes.
I joined a little late. By the time I could join, my lord, the matter had been over. My lord,
Yes.
I'm told that,
Yes,
my
it
lord,
has
may
been
the
fixed,
matter,
I
my
think,
lord,
next.
appear any day next week, my lord, subject to my lord's kind convenience.
It has been directed to appear on 19th.
I'm so grateful to your lordship, my lord. So grateful.
My lord. My
19th
lord.
of this month.
Lordship. There is
My
a
lord,
matter for short passover item number 524. But
524.
524.
Appellate side list. Gone.
Gone.
Done and dusted for today.
My lord, item number 39, it has gone down, my lord, must have gone down that, my lord, High Court administration was not represented. Might be a scar for me. My lord, kindly just indicates that, my lord, High Court administration is represented.
Respondents are not represented. ছিল না? You are appearing for which respondent, Mr. Banerjee, or there is
My
only
lord,
one
High Court
respondent?
administration, my lord, High Court administration. My lord, simply
There
say
are
High
other
Court
respondents
administration.
also, or you are the only one?
May there are the possibly.
Very well. ওখানে the writ petitioner is not represented কিভাবে বলা ছিল? আর respondents are not represented বলেছেন, ওটা কেটে দিন। না, ওখানে লিখেন Mr. Banerjee is present for the High Court administration. The respondents are
So
not
great.
represented. কেটে দিন।
But I'll come back
Petitioner
on
টা
19th. my lord. I'll come back on 19th. So grateful, my lord. So grateful. Grateful.
Thank you.
Grateful, my lord. Extremely grateful.
17 order হয়নি না? 1